October the 22nd. It's 10 o'clock a.m. We're at the Tennessee Tower in Nashville, room G. This is our October meeting of the Inmate Disciplinary Oversight Board. Present in the room is Ms. Betsy Wiseman, Ms. Heather Doyle, Dr. Mary Karpos, Quantel Lindsay, Lee Frank, and Mike Dunn. And then myself. We've got a quorum on virtual. We've got Mr. Dale Carr and Mike Sheridan. And I will turn it over to Director Stahl to introduce our guest and get the meeting going.
Okay, we do have our counsel with us, Mr. Stephen Grauberger. Appreciate you being here, sir. We have a member of the Department of Corrections, Louis Molesnik. So we appreciate you being here, sir. And we will get to them as we go through our agenda. To start off, let's do an opening prayer. Mike Dunn, if you do the honor, sir.
Sure. Let me pray. Heavenly Father, as we pause to begin our day, we want to stop and say thank you. Thank you for the many blessings in life. Thank you for the love and the goodness you've got for us. We pray especially for our leadership today. We pray for our state leaders, our federal leaders, county leaders, city leaders. Lord, would you bless them? Would they rely on you for guidance and strength to continue on the cause of American liberty? Would you aid us in our efforts for justice as we continue on meeting after meeting and as we do what you called us to do? We want to especially pause and ask your blessing on the family of Brother Dale Carr and after the passing of a couple of his loved ones. Would you comfort them today? Would you remind them that you love those loved ones more than they do and they are in your care? So Lord, would you comfort his family? Would you give them joy and strength through this valley that they're going through? And would you remind them that they can rely on you for strength and comfort to pass through this storm? Lord, would you bless our fellowship today? Bless our efforts. In Jesus' name we pray. Amen.
Amen. Thank you, sir. All right, let's move on to our first agenda item, review and approval of the minutes from our last public meeting in September. Those have been previously distributed. As always, a copy of the transcript is available and a copy of the video is on our website. We can move straight to a vote if there's no discussion on that point. I will entertain a motion if there is one.
Motion to accept.
Second.
Seconded. Any discussion, any issues with what was distributed last month? Okay, all in favor, please say aye.
Aye.
All opposed?
Aye.
Motion passes. Appreciate that. So those minutes have been approved. Let's move right into really a big part of our agenda today, the update on sort of the last 30 days. A couple of points, and then we'll have an opportunity to talk with our guest from the Department of Corrections. First, let me just say I really appreciate everybody who's getting me over prolific offenders, so I can get those over to the Board of Parole, and your pending cases, so I can get those over to TDOC and we can get some answers on those. Please keep sending them. Really appreciate that. Last month, the appeals subcommittee met, denied 6 appeals, granted 1. If anyone has any questions about the one that was granted, please reach out to Mike Sharon, who's the chairman of that subcommittee. But I appreciate all the work that the appeals committee does. We have several more today that I'll be sending out again. We got the quarterly DA referral list from the Department of Corrections. We've gone through that. I know we've got a couple of questions about incidents, asking whether or not those have been referred for outside prosecution. That list helps us immensely in understanding that. So we appreciate that from the department as well. I think that got sent out, but if anyone needs another copy of that to look over, just let me know. I'm happy to send that out again. Wanted to update everybody on the case that's pending. We were named in a suit several months ago. We were named in the suit, but wasn't really anything that we're intimately involved with. But I'm tracking the matter. It's been referred for a 3-judge panel. The Attorney General's office has filed a motion to dismiss that should be heard and probably granted here in the next several weeks. So I'll continue to check back in with them and get you all updates, but I think that won't be an issue. Last month, we distributed 294 action forms. We removed 1,112 months of sentence credits from inmates, and we restored 133 months of sentence credits to inmates. So really appreciate everybody's work last month. Look forward to going through the dockets today and continuing that work that we're doing. But all that got taken care of. And as always, we appreciate our staff, specifically Tammy Turner, who works tirelessly after these meetings to make sure that all that stuff gets distributed and out. So thank you again for that. Now, I really want to do something special. We have been here for over a year and a half. We've been having these meetings, and we are really, really lucky because we have someone from the Department of Correction here with us today who has been instrumental in doing the things that we have recognized we'd like to have done, working intimately with us to combine our processes and make the census credit system really, really work well. We had an opportunity to visit last week with his department for over the course of several days. And I have to give a lot of credit to our board member, Lee Frank. He reached out to me with the idea that, and I'm sure everybody's noticed this, that when we send out our action forms to make changes to a census credit decision, the Department of Corrections has a really important policy that prioritizes inmates who might be released within the next 90 to 120 days. So that, as it should, is their priority. So there are some inmates who have extended sentences who may not have updated credits because of the priority that upcoming released inmates take. So Lee said, well, maybe there's a way we can help them with that. So we reached out to the department, got in touch with our guest here, who I'll introduce in a second, and he said, that's great. You know, we want to work with y'all. So he invited Lee and our chairman, Jerry Vassmeyer, to come down and sat with them and talked with them for literally days about the entirety of the process, introduced them to the staff over there, was able to talk about, answer every question that they had, exchanged ideas on processes, and is joining us today. And it just has been an incredible resource. You know, after a year and a half, has really shown up and shown out, and we just can't say thank you enough. So I want to introduce Louis Molesnik. He can introduce himself a little bit, and then we can sort of talk a little bit about what was learned and what our board members did, and answer some questions that you might have. And we can start with Mr. Frank.
No, I was just going to say to everyone, I had this idea you were going to put me in front of a computer and to give me a stack. I'm like, and I got there, and so no one panicked. They were like, that's a legal issue that we're not even going to allow. So I don't want anybody to think that. I mean, I was like, we'll haul trash. You need me to haul some boxes stuff from the. I had this idea in my mind how it was going to work, but they were just wonderful. And Louis, I really appreciate you and your whole staff. Professional, intelligent, really loved what they did, and has to take a lot to, for what they're doing. I mean, they had so much passion. So anyway, I just want to make sure people know that we were not changing credits. That we were not allowed to do that.
Yeah, we do appreciate it. Please, sir.
Well, again, my name is Louis Molesnik. I come to Tennessee Department of Corrections with over 30 years of corrections experience, from juvenile corrections all the way to working at the Supermax at the federal system. So central office, regional office experience, everything from correctional officer trainee to assistant director in my career. So a lot of background with regards to corrections, and just excited to be a part of TDOC and kind of some of the new things that the commissioner is bringing to the table, some updating of processes, updating of things within the department, things that have, kind of been going on for years and years, and just need some fresh eyes, fresh set of fresh attention, if you will, to some of these things. And last week helped me understand a lot more about what you as a board do as a whole, and how that actually is assisting us as a department in helping us move the needle in regards to updating processes and procedures and becoming more effective in a lot of different ways. It was a great week spending time with y'all, and I can attest the first thing that he said when he came down is, "Hey, put me to work. I want to start loading credits." And I had to gently explain, no, we're not going to do that, but here's why. And really focused on showing and demonstrating what our processes are and what all goes into that as a whole, helping them to kind of see the enormity of the task that we have before us in regards to getting the sentences calculated with the number of sentencing impact documents that we're receiving in every month. What some of the numbers I shared with them last week was just as an example, in the month of September, we had over 17,500 sentencing impact documents that we received in paper over here in central office that we needed to go through and process. With that, as everybody I'm sure is aware, we have limited resources when it comes to human capital and technology and other things available to us to keep up with that demand. Throw on top of that the advent of the disciplinary board and what you guys are doing and the decisions that you're making. On top of that, 17,500. Now we've got another 10,000 decisions that we have to manage and get through with regard to the backlog of the discipline across the board. I can say that from our interactions last week, it was enlightening for myself. I hope it was for you all. And we were learning a lot through that dialogue of how we can make this collaboration better long-term. I think we've got a plan moving forward on how to integrate what work you all are doing into our work and make it more seamless and really demonstrate our willingness as a body, both TDOC and the IDOB, in making it better for the public out there. I know our commissioner's dedicated and committed to that 100%, doing what's right for the citizenry in the state of Tennessee. And I think he really shares our desire to make it all work and work well. And I think that was demonstrated last week by you guys coming in and being a part of it and being willing to listen to the enormity of the tasks that we have at hand. We have a lot of plans on how to improve and streamline our services internally. And I think it fits right in line with what you guys are all doing here, the decisions you're making every single month when you're reviewing these cases. I think it's already showing some dividends for us and I think you're probably seeing that some of the outcomes in Thomas as you're doing your reviews and seeing things. We're getting better at what we do because we know we have people who are going to make sure we get better at what we do, and that's y'all by doing your reviews. So thank you for that as a whole. I can't tell you how much I appreciate having partners in our quest for improvement in our outcomes.
Yeah, that's one of the things that got discussed, I think, when we met was some of the needs that you have based on the volume that you're seeing because of some of the changes that are being made and some of the oversight that's being done. And so, part of what we plan on doing is delivering that message of needs to the legislature because we want to be able to make sure that the things that we're doing are actually effectuated. And so if you do need resources, technology resources, personnel resources, whatever, to effectuate the decisions that are being made and the priorities that are in place, we want to support that on you guys as well, because, to Mr. Frank's point, I mean, we can't get in there and actually type this stuff. And so it's really a big part of making sure that everything works from beginning to the end, because if there's a disconnect in the process, then what we do doesn't actually happen, and we just can't let that be. So we look forward to working with you all on making sure you have what you need to do the things that we're trying to do, and I think that's going to work well. But let me open it up. I mean, Mr. Malusnik has taken his time to be here. I think he's open to any questions that anyone has, processes, procedures, anything at all. Does anyone have anything that they'd like to ask?
Question for you, sir. What is your biggest need over there to get over this hump?
Where do I? I've been doing this job now since July, and I've spent a lot of that time assessing and evaluating processes, procedures, seeing what our staff are doing. And I can tell you that my staff that I work with every day are truly dedicated to what they're doing. They're passionate about it. They care about it. They want to do what's right for the people involved. And they recognize the work that they're doing impacts people on a very personal level. And at the same time, the work impacts them on a very personal level. And with the volume of it, it's obviously mountains of work that's coming in every single day. So when it comes down to it, we're going to address some of those through the department as far as requests for resources that fills a lot of those needs. We recognize that we need to modernize a lot of our infrastructure and processes and things of that nature. The technology is going to go a long way with that. And we're taking steps to address those now as a whole, but as everybody's aware, it takes time. It takes approvals. It takes, budgets to be passed and all that kind of stuff. And we'll get there. But I think one of our most glaring needs is time. We need more time to be able to do the work that we're being asked to do and meet the changing expectations. I think by the mere existence of the board is a demonstration of the state of Tennessee expecting something different from the Department of Corrections as a whole. And we just need time to be able to make sure that what we're doing fulfills all those needs, meets those expectations in a way that is not going to detract from the safety or the security from anybody in any of our communities. So really time is of the most important need that we have right now.
Sure. Okay. Thank you for coming today.
As you try to modernize, that's what I was thinking, because the paper comes here, and I mean it's it's moving paper from the courts in all 95 counties that come in, or however many counties that have criminal court, and then you have on top that didn't used to be until we came about, all the paper coming from the 14 different facilities that are actually taking time. I mean, so you got thousands of those, and then you have ours. And so you're trying to modernize what you've got in the last, 8 months, piles of new paper. So it's not even like what you were trying to modernize with what you had, but now you have.
It's a matter of modernizing and digitizing records from all sources. We get information not just from the board, but obviously from all the courts, all the jails, all the institutions. We get documentation and requests for information from families and other entities out there, the district attorney's offices. We're getting information in paper from everywhere, and it's coming in all different mediums, whether it's FedEx or UPS or the mail. Also email, and believe it or not, we're still getting faxes from different locations on things. Trying to corral all that information and get it into a more usable format so our procedures and practices can be streamlined and become more efficient and have things completed at a faster rate than what they are now is going to be a big part of that modernization as a whole. And I'll tell you, long before I came into this position, the department's been analyzing and evaluating how to go about doing that. But this is a big undertaking. It's a huge task, and it is changing things even beyond the Department of Corrections' ability to change things. So having these kinds of interactions, this kind of dialogue with you all and getting to understand what you guys are doing and developing helps kind of speak to a plan moving forward for other areas of modernization, because I like what you guys are doing as far as sending the information to us electronically, because that helps us get better and not have to manage the actual physical paper like we have to do from all the other information streams that are coming into us. So it's going to be more of that kind of thing to really make it happen. It's going to have to change from other areas. I know we spoke a little bit about standardized judgment commitments and having it come in a digital format that I think speaks to safety and security of the information that we're being entrusted with. And I think there's going to be a lot of that we're going to be talking about moving forward that I think is really going to help that modernization process as a whole. But it's a good start for me to.
One last thing on what Mike and Mike Ward seems just really super sharp guy. On our benefit, the putting us into the system, that was fascinating, because that's things that we need. Instead of typing in, I need this, you go and everything's there from the beginning to the end, the face sheet, everything you need to know is right there. And so I don't know if you want to go over that just for a second.
I think you're absolutely right. Michael Ward is amazing. He's out of the box thinker, and definitely not, status quo kind of guy on things. And that speaks to the leadership from the commissioner on down through the assistant commissioners, deputy commissioners, and all of the people that are reporting through all different aspects of the Department of Corrections. We're changing the mindset in trying to figure out how to modernize all aspects of it. And really what Mr. Ward's been able to do is take existing procedures and practices, come up with enterprise-wide solutions to it all that help, incorporate all the decisions that go into the inmate discipline process and really get that into a format that is more easily processed by our folks on the sentence management side, more easily communicating externally with the board and incorporating what information you guys are submitting into our existing processes. It really is a matter of taking and eliminating the paper as the foundation for everything. And he's found a midstream process that is functional and works and actually helps us track and monitor and communicate what needs to happen moving forward. And I think not to go into too much depth about what happens at the institution level with it, but they're really still working on paper every single day. And I think it speaks to an opportunity to modernize all of those processes, digitize things as we're moving our institutions into the modern information age as well. I think plugging you into our processes where we've kind of got it slated at this point in time will, I think, make your jobs easier as well. I think you're not going to have as much downtime waiting to get responses from us as we're going to provide you information on the front end of your work and your review processes. I think it's going to really help streamline for all of you what you're trying to do. And it gives us an opportunity to look at other ways to kind of improve in that same vein. Like you said, brilliant work on his part. His work with prison operations has been amazing in modernizing something that really has been the same way for decades. And it's just going to be all of us capitalizing on that moving forward. And I'm using it as motivation to modernize our processes on the sentence management side and the record side. So it's really good stuff that we're trying to do. And again, I'll attribute it back to if you all didn't exist, we probably wouldn't have been looking at it in such a dire need to get things moving. So there's some positive benefits of all of this relationship moving forward.
I'd like to say, which Lewis put up a lot with Lee and I for 4 days. But
I didn't ask one question.
We've known him 2 years.
I'm just kidding.
Lewis and his staff, they took time, and I've got credit. Lewis took us on every floor in the Department of Corrections, even the basement under the Andrew Jackson building where all the records from a tornado were stored. It would fill up this whole side of Tennessee Tower. But his staff, they took time, and each one of them, from receiving sentences and the processes from the jails, moving them in, sat down with us and explained step by step, taking hours out of their time. And everybody up there was so helpful. And out of all the floors, the second floor, their floor, it's quiet as a mouse. And it looks like mice running back and forth. They don't say a word, but they are constantly busy. They validate every piece of paper that comes in from the court 4 times before it goes into the system. And the commissioner, I want to say thank you to the commissioner, all of his staff, and especially to Lewis, because after the 4 days, I think he decided that he can't take all of us for 4 days anymore. So I think he's going to kind of make it a smaller learning process. But it was very helpful, because just in the 7 years I've been out of office, I didn't realize how many laws had changed. Just how, because Sonia Brown gets all the paperwork that comes in from the jails and everything. and we were talking and she said, you were a sheriff. And I said, yes, ma'am. She said, did you ever know Jim Brown? I said, yes, ma'am. That was my go-to man. He worked for the Department of Corrections. He was who we would contact to get beds at prison. She said, well, that was my dad.
Yeah.
And she was going through it. I said, well, this is sheriff stuff here, so I was understanding. But then she started telling me the things that have changed now. The automatic 8 days on good behavior for the pretrial people is not an automatic now. There's a form being filled out for it that the sheriffs have to do, which is much better because in the old days, we had to give them by law 8 days. And if we wanted to dispute it, I had to get the district attorney to argue before the judge why to take it out. Well, now there is actually a form the sheriff can fill out and say that this inmate has not been an exceptional inmate and they're not getting the free time. Good time, but Lewis is also going to be over our liaison. The commissioner is dedicated liaison. He will fall under Lewis's staff, and he is Mr. Automation because Mike Ward has already got all 10 of the state prisons online. They are scanning their documents real time into Adobe Sign, and they're going to share all that with us. Or all you got to do is type in the name, the facility, or the incident number, or the TOMAS number, and it'll pull up everything from that deep forward hearing, including photographs of if there's weapons, cell phones. They lack the 4 core civic prisons because they had to get licensing, the sharing of the Adobe. But
When will that start?
Which part?
sharing with us.
Everything being online from the two board.
So we can look at it.
Okay, we actually have to work out the exact start date to kick that off, but it's coming soon. We have it set and ready to go in that aspect. Because again, my board had done so much of the legwork in automating it all. We'll see when we bring the 4 contract facilities online, because I'd like to have that done beforehand, just to make sure that there's not any additional processes being developed for streams of information, because that oftentimes presents itself as a problem. Because I know we spent a lot of time trying to, just from the sentence management side, aggregate all of the different data streams coming in for modifying and removing credits on folks and trying to figure out where it's all coming from, how to get it in a usable format for us to be able to process and get it done timely. We're still working through some of that from a procedural standpoint to make sure that we're fulfilling y'all's needs with what's going on, because you got a lot of things that you guys you're making decisions on that, quite honestly, we weren't sure how to manage that on the front end. And I think the analogy that we used when we were talking was that you guys were building the plane as you were flying it. I'm kind of in that process too, to a certain extent, trying to build the processes as you guys are trying to utilize it. And the more that I can have ready-made for you, the easier it'll be, and we won't have to try to go back and bolt on patches here and there. But it won't be very long at all, because I know they're making good progress in getting that done for the contract facility.
Yeah, so like, I remember she said, if you take a year, you don't just go 360 days, they do 6 days, 6 days removal, 6 days. So that's, what is that? I can do my math there. 6 times 60. Is that right? 360.
The number of transactions.
It's just process of a human process to have to do that.
Well, we've got TOMAS, which was, a legacy system that's been around for decades and decades, and it's not been modernized as quickly as we like. And we're in that process right now as a department, and it's going well, and we're making strides in things. And we're looking at those kinds of end user issues that we're resolving through the new system that we're developing. Because right now we get a sentencing impact decision made, no matter where it comes from. Sometimes we've got to touch that same piece of paper 17, 18 times to be able to actually get it in the system to reflect what the decision was. And that counts for everything that you guys are doing. If you decide that we need to take, 9 months, 12 months of credit and remove that from a sentence, we have to touch that for each and every month, depending until we get everything calculated out for the number that you determine needed to be removed. And those are things that, we're making headway on.
Yeah.
But to Jerry's point, I think you kind of got to see and feel the passion from the people. They're amazing and wonderful, and they're so good at what they do. They're just thrilled to death that y'all were able to come over and, have some interest in what it is, because it's not something that garners a lot of attention. It's kind of more of the mundane routine. People look at it as simply data entry, but there's a lot more to it than that. There's a lot of technical evaluation of judgment orders and directives that we get from different people that they take into consideration. And it takes a lot of years to develop the skill set and the experience to be able to do it right. That's why I couldn't let you do it day one.
I understand.
But ultimately, you can see that there's a method to the madness for what they have to deal with. And the fact that we're able to advocate for the work that they're doing, we're able to collaborate with folks such as yourself in improving it. I think it speaks volumes to the commitment that they've made to stay on doing this stuff. Because as well as I do, if they don't care about what they're doing, they're not going to stick around. And these people are really passionate about doing the right thing. And I hear it from them all the time when I'm meeting with them and talking to them, going around meeting with them in their cubicles. They know that that's somebody's family member, somebody's life that's being impacted by the decisions that are being made that they've got to process. And they want to do it right. They want to get it absolutely right. They want to make sure that we get people, we hold on to them for the appropriate amount of time, and that we hold them not a second longer than we're supposed to on that, because it's the right thing to do, and that's what they're dedicated to. And I think that really came through with your interaction with them all. And they were just so impressed that you guys were able to speak to and articulate their language so much in Thomas and the system. You understood the screens that they pull up all the time. I still have to ask them, explain that to me again, because I don't understand the vernacular and the terminology and the acronyms that they use as much in TDOC versus some other systems and things like that. So they appreciated the level of professionalism you all brought to the table in trying to learn what they do and actually appreciated somebody's interest in it all.
Yeah. One last thing, and I'll be quiet on that. This is just something that I was very impressed with. Lewis found one of the cavemen that worked on Thomas, and he and Crystal that puts all of the sentence reductions in Thomas are developing a system where Crystal showed us what it will do right now. She can type in like the Thomas number and it bring up all the priors. And as we have to go back and look at priors, we'll click, we'll have to read it, then we start all over, click. She's got it in a sheet where they've extracted it. It will give every prior that was an A, and it give a little narrative of what was done on it. And when they get that developed, that's going to be awesome.
And we'll be able to do that eventually.
Well, I'm not sure exactly how far that'll expand depending on the development of the new system, because the new system, I think, will be able to incorporate more of those kind of retrieval tools into the interface. Like I said, that's still kind of all in the development stage of it. But what we decided was we looked at it and we said, okay, we need to know the entire universe of discipline for an individual and what's going to be a sentencing impact function of that. And that's where we started asking questions from our technology folks saying, how do we go about getting that? Because it's not real user friendly as far as running reports and retrieving stuff like that, unless you're really, an expert in the system, have been doing it a lot of years. So we figured out a way to retrieve the Class A's and identify them on one sheet so we can speed up our process of getting those credits removed and the actions actually entered into the system. Come to find out, there's some things that were, midstream changes in regards to the matrix and some of the things that are classified as Class A versus B or C. And that kind of helps inform us. So I got to go back to the technology folks and make sure that those changes are incorporated into this tool that we're trying to trying to develop and get it working for us. We'll see how it goes, whether or not I can actually extend that tool further or not. I'm sure there's going to be some opportunity for that, but I want to make sure it's right before I start, because I actually have one person doing it right now as a test for all of it to make sure that it's right and it's retrieving the entirety of that disciplinary universe so we can get it right the first time. It speaks to the efficiency aspects, the incorporation of technology and trying to make it streamlined and user-friendly as we possibly can to get it done. Because I know everybody gets frustrated with backlogs and that kind of stuff. But again, to your question, I need time to fully develop it right to make sure it's functional for everybody to be able to use. So we'll see how that kind of ends up in the long run. But I'm very hopeful and encouraged by early results so far.
Yes, sir.
For one, sir, thank you for being here. Two, glaring report, if you will, from Lee and our chair. They had a great time and bragged on your staff, the hospitality. And I just think it speaks volumes that you came here today. So thank you. And to share.
Well, thank you for inviting me and having me. I tell you, coming to the great state of Tennessee, it's been, I've
That's
felt
one in the union.
open arms from everybody. I've been felt very welcomed. And the fact that we've got a shared goal, shared objective, I think it's only right that we support one another moving forward
Yes,
on
sir.
things, because I think we all want the best outcomes for the state across the board and for its citizens. No matter if they've been an offender or not, it's still, like I said, my folks see it as these are people's lives that we're dealing with. And if we're working well together, it means that we're going to eventually have the better outcomes for everybody in the state. So it's the right thing to do.
Yeah. And I appreciate what you said. One last thing for me, for sure, is in front of anybody, the law, the lawyers or whoever we were in front of, you were like, this board has really helped us. You weren't trying to act like this was all, you were giving us credit where credit was due. And I really appreciate that. And you had no qualms about telling anybody that you thought the board helped in moving along the process. So I appreciated that.
Yeah,
To admit that, that's great stuff.
I don't think I have to admit it. I think I'm just stating facts at this point. That,
Okay.
that there's
Yeah.
an expectation from the state of Tennessee. The legislature made it clear that the expectations are changing, and we have a responsibility to fulfill those expectations and do the right thing for the state as a whole. And hey, look, I'm not so proud that I'll say that I'm the smartest guy in the room or anything like that. Oftentimes I think I'm probably the least intelligent person in the room with dealing with these folks, dealing with the sentence management stuff. But at least I understand I have to seek out resolutions and answers and information from people that have it where I don't. And I think it's important to recognize that we all have contributions to make. And you guys are making a contribution, and I would be a fool if I didn't capitalize on that stuff and recognize the work that you all are doing every single day, because it is in furtherance of the exact same mission the Department of Corrections is taking on every single day, and that's to have better outcomes for the state of Tennessee. And we contribute to each other's success, so why not brag about that a little bit and talk about that? Because like I said, I think there's going to be more that you guys as a body reveal to us and help us see things in a little bit different light that we wouldn't otherwise be exposed to, and helps us improve and helps us with the furthering the agenda of the state of Tennessee in providing better services for all of the citizenry. It's a good relationship in that aspect.
Thank you.
And just so you know, Mr. Lindsay, the invitation has been extended to everybody to try and it's just, it'll be a little bit, 2 or 3 at a time.
I'll tell you, they wore me out.
Yeah, it's a lot. Well,
It's a lot, but it's good.
but we also take a lot of time from your staff. And so that's why we're thinking we can portion it out a little bit, but hopefully we can get everybody over there so they can get their questions answered. I think this is just sort of an introductory thing. I don't want to keep you on the hot seat forever. But if anyone's got any sort of broad questions, now's a good chance to just kind of ask those.
Yeah, since we are on the public record, this is a good chance to just ask some common questions.
Okay.
So we recognize that, for instance, with sentence credits, there are behavior credits
Mhm.
and there are also programming credits.
Mhm.
And there's a limit on how many of those can be earned every month. And that's to some degree affected by what classification the individual is currently in. So when the board makes a decision or when we have on our docket, since we don't speak in days, we speak in months. How is that interpreted? So let me give you two from just somebody on the streets listening to this conversation. Where you're taking a month of credits away from them. Does that mean you're only taking the amount of months that they could or earn in that particular days that they could earn that in that month? So let's say I'm eligible to earn 6 behavior credits and 6 programming credits. So I could earn 12 in that month. So when they take a month away from me, does that mean that they're only having those 12 days taken away, or does it mean something different?
The short answer is it depends. Because one thing that I've come to appreciate about this Tennessee sentencing laws is that they're very, very complex. And there's a lot of variables that go into all of that stuff. And a lot of it depends on when you were sentenced, how you were sentenced, what type of behavior credits were earned, when they were earned, and all of that. It's not a straightforward answer that's going to be easily, fulfilled as far as a resolution in this forum, because it really depends on the individual. And I've really come to appreciate that every sentence that we have for every individual is tailored. I mean, tailored to that person's exact situation, leading to the complexity. It's all nuanced. I don't have a pat answer that would just answer that across the board. But in generalities, if you're taking 12 months, we're going to take in all the credit days we can from all the different areas that are available. Roughly speaking.
But per month, are you taking 30 days? Or are you taking only what the individual earned in any given month?
Again, it depends, because there's also the other aspects of risk and needs assessments that have to come into play, whether that they're actually earning this, that, or the other. We have to look at it on a case-by-case basis. And by no means am I an SME at the level that the folks are that you guys talk to. So I don't want to, misstate something.
Well, then I'm okay with
Yeah.
maybe next month. Bring more of your staff so that we can ask, because people always ask me, they'll say, okay, I see these dockets and it says like, oh, you took 30 months. Okay, well, in my mind, 30 months would be 30 times 30 days times 30 months. But I'm not sure, because reading the sentencing manual, I'm not sure when I answer somebody, what did that really mean? That you took, let's say 12 months, just for the sake mathematically, did they really lose 365 days because you took 12 months? Or did they really lose however many credits they had earned across the course of 12 months?
And that's a very detailed question for this, again, tailored to an individual. We can talk about some examples and we can get that offline from here, and then we can probably figure out exactly how to answer that question in general terms. But I don't think a general answer is going to fit every scenario.
Well, and I agree with you. I think that while we're giving the impression that it is pretty standardized, if it's 12 months, then it's 365 days, except not always. So I think being able to parse that out just for the sake of the public and for the sake of the General Assembly, so that we're very clear about how many does that actually mean?
And how it actually impacts the overall expiration date, red date, and all those other dates, because
Right.
those move around based on all of these decisions.
So that gives me my
Yeah.
second question.
Yeah.
And I know we may talk about it again next month, and that's good, because I think it's an ongoing dialogue. And did I hear correctly, you're going to be our liaison?
Well, actually, we're getting a liaison.
Yes, no?
We are getting a liaison.
But you'll work closely.
I'll be working out very closely with the board.
Yeah. So let me ask you this, because sometimes when we look in Thomas, we recognize that the person doesn't have a lot of credits.
True.
But when we're applying or we're looking at how TDOC applied their matrix and assigning the removal of credits as a sanction, what does happen when there's a deficit?
We talked about that at length, and we actually had a drawing last week up on the board showing all the variables and how those dates move and how they lock together at a certain point when the red date gets pushed all the way out to the expiration date, and how that becomes problematic. And really, again, not the SME with decades of experience with that, but it really does get to a point where there's days that you're asking us to take that they don't have available to take. And we're actually looking at how the system itself calculates that and shows up as the removal of those dates. It doesn't go in the negative. And then, we've got where it can go into a negative situation on that. We just found out last week by having that dialogue, where at least I found that. My folks probably think that, but I became aware that it can actually go into a deficit situation with that. And then there's questions about when do they earn? What's that do to the red date? What's that do to the FX date, the EXP? It all just is so variable. It was kind of amazing. Again, going back to the earlier statement about how complex all of this stuff has become through the sentencing laws over the years.
It seems like on the red, once the FXP and the EXP, and then you can have, I had an example of, he was in for 35%, like 28 years, something like that. So he was flattened out, but his red was still like 15 years. He's way up here.
And just
And
for the
from what
sake of
we
people
found
who are
out when-
watching, a red date is the release eligibility.
Right, when they can first come up for parole.
Right.
So that red starts moving back. So when we're taking time that they don't have, the
It's
red will
postponed.
move to where all three will be aligned. And at that point, legally, that's it. That's as far as it goes. Once they're all three lined up. And and we talked about this, there is no like 3 years in the hole that you've got to, have no disciplinaries, and you move from there. Actually, once they're flattened, if the next month he can get credits, then he starts moving in the positive again. That's what you're.
Okay, and now that's actually my question. So do you hold over? Let's say, just for an example, we ask for 30 days to be taken and the person only has 15. So you take the 15 off, but we had asked for 30 days to be taken off. So in the next month or in the next year, if they earn another 15, do you suffice that original 15 we asked you to take off? Or in that moment, you say, here's what they have. We take what they have, and that's the best we can do. And then as they start to earn more, you don't go back and take the 15. That's what
Well,
I'm
that's
asking.
part of what we're researching right now. We're in the process of trying to answer that exact question, because through our dialogue and our conversations, we know that the system will allow us to go into a deficit for that individual. Now, what happens when they start, we haven't crossed that bridge yet, so we're trying to figure that part out. So I don't have a definitive answer for you today on that, because
A sentence extension, right?
it's really not a sentence. I think that's
not a good.
Yeah.
that's the wrong.
Okay, that's
wrong
true.
term.
That's the wrong term.
That's the wrong term, because we really don't have, I think the judges are the ones who can add sentences since it's time and that kind of stuff. We're actually just dealing within the sentence structure that they've been sentenced to. But we got to figure out how that's going to work, because that really hasn't happened. And we're in uncharted waters in some of this stuff, that these are specific scenarios that haven't existed before.
Right.
And now that we are, in full stride with regards to holding individuals accountable for misbehaving inside our institutions, with the removal of these credits, we're seeing some unique scenarios that really were more hypothetical before. Now they're coming into a reality, and we're going to have to start figuring out how that works. And like I said, we're doing some research on that right now, because that one actually kept me up after we spoke about that. I'm like, oh, I have no idea. And my folks don't necessarily know, and that's an uncomfortable position.
It's a culture change, and we talked about in 2021, this is fascinating. There were 36 individuals in all of 2021 over 14 institutions that lost time. 36 only. And we talked, and it was just policy, unless escape, homicide, there was not time taken from inmates. And so it's a total culture shift that now a lot of time is being taken. So.
But that's, I think, what the public wants concerned. Their concern is the confirmation that when our docket says X number of days or months is being taken, is that in fact being taken? Sometimes it's not possible because the time doesn't exist.
Right.
But then what happens to that limbo amount that there wasn't time for them to take? And when they begin accruing, remember last year I brought up a case of someone who was convicted of rape and they had a disciplinary for rape and they took their time backwards, but the very next month they began accruing good behavior. And my question from that point forward was the remainder of time that wasn't available to be taken because they hadn't accrued it yet, as they're now accruing it, are you going back and satisfying what the original docket asked to be taken from that person? And I do understand this is a dialogue. It is something that has to be examined and understood. And one more time, it is why the board exists, because we're in this conversation about how to ensure that what we're saying is possible to be withdrawn, because we don't want to mislead the public and say, well, we're taking all of this time away if some of it actually can't be because the time doesn't actually exist. So maybe the reconciliation long-term is, while, I might have asked for 12 months to be taken away, in reality, the person only has 6 months. And so in reality, the outcome was 12 months wasn't taken away from them. Really only 6 months
Right.
was taken away.
Is that more a question, Carpos, for lawmakers and attorneys? That's something with the board? I mean, we're talking, what he said is complex.
I just want confirmation from the agency in a position to take the time, because we're sending over documents saying this is our decision.
No, I get your question. I was asking, is that an agency question as much so as like a legislator, a law, something to me, like, can they do that? Is it legal? I mean,
I
can we
think
take
it's
Those
both.
make
I
good questions. Yeah, we may need to find out.
One of the things we came to was there's a duality there.
Okay.
And again, they're in a difficult position because what we heard was you're trying to do everything we're telling you to, asking you to do, but you can't sometimes do everything we're
Sometimes
telling
the
you to
sentence
do.
structure only allows
And
us to
that's-
do.
Yeah, and that's sometimes because the system won't allow it to happen. Sometimes it's because the law won't allow it to happen. And so, but the commitment is there to try to do everything that we're asking you to do. And it's just a matter of whether or not an obstacle is because it's statutory, or if there's an obstacle because Thomas won't let, but we're
Well,
looking at it.
He said it was complex and.
Yeah.
I don't want to say that the system is the limiting factor. It really relates more to the sentencing structure, whatever the individual is sentenced under, and the time available, the time not available, all of that plays a factor into kind of the scenario you're talking about. And that's why we have to comply with whatever that judicial sentencing order was.
Yes.
And that dictates the time that we can and cannot take. Like I said, we're getting into some areas where it was like not really foreseeable at the time because we really weren't in this space like we are now. So we're seeing some unique scenarios coming up that we're going to have to develop our processes to deal with and communicate about how that actually is impacting it. And like I said, that was the conversation that we had last week that spurred a lot of dialogue back and forth in the drawing on a sentence, how it impacts it, moving backwards and forwards, and what impacts where and that kind of thing. And I think to your earlier point that there was an intent to take this amount of days. This is what we're going to document that's been taken. Now, whether or not they go into the deficit and can, dig out of that whole thing we're working through right now, because we don't have a mechanism in place right now to really account for that because we haven't seen it. So it's a new process that we've got to develop, and we're working through all that and examining that, trying to get that exact answer developed, because we need to know.
Yeah. Well, and what I would be asking for, and I speak only for myself, certainly not for the board, is if a document from the board is coming, let's say from my docket, that says, here's what, for these people, I'm asking, and the board affirmed their belief that that was a reasonable request, that the following be removed. And you get individual papers for each individual, then I speak only for myself. What I would like in return is a confirmation of what exactly was taken. So then there's that understanding of this was requested and this was what could be complied with, given, as you say, all of the variables that impinge on the ability of the agency to do that. But now we have a true record of what exactly was taken. We currently have the decision of the board, what we're asking to be taken, but in return, having a confirmation of what was actually taken. Then we have a complete record of the outcome associated. We don't leave people to assume that just because we sent the paper, that's exactly what was done, because I understand the constraints.
Yeah.
If I
But isn't
could
there
add-
a way to go in and check on it? Is it, you go in and
You
check?
actually go into Thomas and you can see what was taken. And that would be the official record, because that's where we do our data entry with whatever decisions, that's where we annotate it all.
If I could add something, when you had Crystal come and talk to us, and she is a dedicated lady. She actually told us, she said, you know, I took this job not for the pay, but for the safety. I don't want anyone hurt on the street, and I don't want to take anyone's civil rights away from them in prison. So she said, I do my best to make sure everything's right. But to Dr. Carpos's question, and I probably have it in my bag, she brought in a stack of paper was showing us, and she said, when y'all deal in months, and she had her paper, she said, when you take a month, I'm taking 30 days. You take 2 months, I'm taking 60. And she has to go on the green screen, and she showed us, you know, how she's green screening it. So she said, now this is on people because the sentences have changed back, you know, 93, 87, or whatever. But the newest inmates that have been through all their evaluations and all, where they can start accumulating sentence credits. If we take a month, she's taking 30 days. And she said, you know, if it's 12 months, it's 360 days. And she said, it's 6 times 6. She said,
Gotcha.
yeah, I have to go one at a time. And
But I think it speaks to your other part of the question with regards to, if they don't have it to take, what do you pick?
Right.
Where does it go? That kind of thing. And that's that kind of that unknown area that we're working through right now. Because you tell us to take 9 months, we're taking 9 months, and we're gonna figure out what that looks like for each individual.
Yes.
Because it's gonna be different for each individual depending on things.
Louis, can you just talk quickly about, to Dr. Carpus's point about the public feeling confident in the effect that we're having, how you guys prioritize an inmate who might be getting out sooner rather than those who still have a substantial amount of time on their sentence when we send disciplinaries over, how you find those people and make sure that they're being prioritized so that no one is being released that should be released early because they had sentence credits that should have been taken but weren't. Can you just talk a little bit about that?
Absolutely, absolutely. Clearly, a priority for the department is to make sure that people get out on the date they're supposed to. And if there's an individual that's coming up for parole or has a release date that we need to, complete their sentence review prior to, we're doing that months in advance, and we're trying to get that as early as possible, 3 to 4 months in advance of that projected date, whatever it might be, or that hearing date and things. We're aggregating all of the disciplinary information that we have available to us. That's why that retrieval tool was being developed, so we could get the entire universe of an individual's offense behavior inside that would actually have an impact on that potential eligibility date or parole date for things. So we're getting all that together and calculating through all of that to make sure we're getting it and prioritizing all of those dates, those individuals coming up earlier rather than those that say have a red date in or release eligibility date, 15 years from now, 10 years, 5 years from now. We want to make sure that we're focused on the front end of what's the most immediate potential for release and making sure that those are right and accurate as soon as we possibly can. We found that in a lot of instances, because of the archaic processes that existed, because that's just the way it was, and we weren't accustomed to the volume coming through, that it was real manageable back in the day. It really wasn't as big a dropped football, if you will, if we missed that, because we had time on that because we didn't have the volume. Now everything's coming hot and heavy, it's coming fast. We're getting a larger volume, so we had to figure out different ways to streamline that and get that funneled into one data stream for a person to be able to look at and get it done as early as possible. So the information that you all are given, we actually, when we find out that somebody's coming up, we'll actually go out and we'll extract the forms that you guys have sent over. We'll get all of the incidents, all the reports that we have pending in our paper system, all of the forms that we have that might be haven't made their way through the mail to us in central office to process. We're actually going through that digital process from prison operations and grabbing that information now. And we're looking at all of that stuff, but we're prioritizing it based on that potential release. No matter what type of release it is that's coming up, we're prioritizing on that and getting it done. So therefore we make sure it's right. And in some instances, it changes that date. And depending on the sentence, sometimes it doesn't change that date, no matter how much time it's taking on that date. Maybe they flatline and everything's locked in and that date's coming and we can't hold them past it. But we're making sure that those are the cases that we move to the front of the line for processing to make sure it's right. And we get it so we don't have incidents where people are getting out early and wrongfully.
Yeah, I just know that was a question that we had, and I walked away feeling much more confident, having that discussion that was being done.
And really, I hope you derive your confidence in what we're doing based on the passion of the people that you got to speak to. And that's why it was so important for me to have them speak with our subject matter experts so they understand, they get it. They understand the magnitude of the work that they're doing and that it is impactful on a broader scale. It's not just moving a piece of paper or doing some data entry into a computer. It matters to people's lives. And it's important that we get it right, and we get it right soon.
Well, we do have a little bit of time. Dr. Carpenter, did you have something more?
I'm hoping you come back next month and that this is a continued conversation. I, for one, have found it incredibly useful and just welcome you to come back. And if you have business cards with you by any chance?
Only been doing it a few months,
Yeah.
still trying to navigate some of the other things. We're trying to hit the ground running and actually get the work going, but my contact information they've got available.
Anyone else in the room for Lewis? Anyone online? Dale, Mike Sheeran, any questions that you'd like to ask? Yeah, Mike.
No, just thank you very much for being with us and being here. Just I've talked to both Lee and Jerry about their visit last week, and they said great things. So certainly appreciate you taking the time. And I'm sure they went over. I don't know if you guys are hearing me. I'm getting some feedback. Can y'all hear me okay?
Yeah, you're coming through good.
Okay, great. I'm sure they talked to you about the inconsistent application by your folks on the your TDOC on the matrix, and I know you guys are working on trying to fix that. That's certainly something that we all struggle with and have for some time. So hopefully you guys can clear that up soon. And then the pending incidents, I know you guys are trying to help us with those. We've got some. I've got like a DSO, a drug possession from December 1st. So if you can, your folks can continue to work on responding to our questions. Mary, I thought those were great questions, and certainly the idea that getting a response from TDOC and maybe that's a legislative fix down the road, but I think those were great questions. But anyway, Lewis, just thank you for taking the time. We certainly appreciate you and what you guys are trying to do.
Thank you very much. I appreciate it. And I think there's a lot of learning to be done by everybody involved, because this is some new territory, to say the least. So.
Great.
Thank you so much.
Yes, we're grateful.
Thank
A
you.
round of applause.
Yeah. Why don't we take a 5-minute break? We'll let Mr. Malusnik take off. People can ask him questions on his way out if you want. And then we'll come back and we'll just run through the rest of the meeting that way. Okay, so we're going to take 5. Everyone online.
Thank you very much. Right.
Thank you.
Absolutely.
Can you just mute it and turn off the video?
Bless you.
Thank you. I was eating a bite of apple and stuff here. It's lunchtime, my time.
It is. Yep. It's almost lunchtime here.
Hey, let me tell you, are you still on there?
Yes, sir.
On that one, I went back and looked at them, and I took that one off that had the 4 hours. I just took it off and sent a revised thing. On that bottom one down there, let me get to it.
Okay.
I thought I had it right here in front of me. I saw someone going to take 3 back front, not go down to 3. He just back to the pocket.
Okay.
Back later, coming back on now, but you know what's the plan on that?
Say, you could all think on straight A students, it's 9 months time, minus 12 months time.
Mike, Dale, can you guys see us?
10 years.
Yes, sir.
I'm here now.
Okay, great.
And you guys ready to go?
Yes, sir.
Hey, Lee, you ready?
Yeah, try to stay on.
And then now.
They have made
I know, I'm trying. It
It
was great. I mean, right? Like, you know, I know we got things to do, but that's a good opportunity to kind of.
I'm well, how you saying, what's up?
Well, yeah, the liaison's gonna work for him. Once they hire.
So you'll work for him.
Yeah, but he's not gonna be the assigned liaison. But for right now, he's the assigned liaison for sentence management stuff. We're still working with them on like the matrix and stuff. So we got kind of dual, but once that person comes on board, they're gonna be the funnel, but they're gonna work directly under Lou. So having that good relationship is gonna be helpful.
Wow.
Hey, Lee?
Next 3 days.
Yeah.
We're getting all of our.
Hey, Lee, you ready?
6 minutes maybe.
And thank you for sending that to me. I opened it. I was able to scroll through it.
And,
All right.
Congratulations.
Well, okay, hey, everybody, I'm gonna start the recording again and we're gonna go back online. Okay, we're back. Appreciate everybody coming back. Small break. I thought that was incredibly helpful. Appreciate the questions. We'll continue to dialogue with them as we move forward. But let's go ahead and plow on here. Just real quickly, moving on to our next agenda item, outstanding matters, really just the annual report. We're gonna be putting that together, hopefully getting that out for review sometime next month. That's really the big outstanding matter to discuss. We have approval into the record of initially reviewed incidents, which you can find on tab 2, after tab 2, tab 3. So if everybody wants to take a look at those, close to 800 this month, everybody okayed, bringing us past 4,000 for the year. So if there's a motion to move those incidents into the record, I will entertain it now.
motion approved.
Seconded. Any discussion? All right, all in favor, please say aye.
Aye.
All
Aye.
opposed? Okay, passes. Thank you very much. Moving on to our next agenda item. We were going to discuss the sentence management meeting that happened last week, but we really went through that just now, so I'm not going to belabor that. Any other thoughts, points, quick issues on that from anyone? Okay, great. So we will just move on to the incidents now. We have our first presenter is Mr. Carr.
Thank you. Can anybody hear me?
Yes, sir.
Yes, sir.
Okay, let me get to my instance here. Okay, well, as you see on my instance there, and I can explain some of them here just in a minute, but I'm doing, the D board did 432, I upped it to 713, so I'm taking an additional 281 months off of all those there. And then I'm restoring actually 25 credits back. And Mike had asked me about one. I'll go and explain it. On that very bottom one, on the one I'm restoring back, and I've got some other things about the other one, but on that one I'm restoring back, on that 168-4970, the D board took 12 months off, and all the guy did was spit his pill into his pocket. And maybe I thought that was a little too much, so I went back to what the matrix said, 9 months, and giving him back 3 months on that. Y'all can discuss that. But let me discuss a few of the ones. I had a whole lot of violent instances this month. I mean, it just seemed like I had bunches and bunches, and I wanted to go over just a few of them with you. Is the reason that I changed them. On Bledsoe, incident 168-4069, that inmate punched an officer in the face, bit his arm, and the sentence credit reduction was only 8 months, and I put it down to 15 because I mean they attacked an officer, and I don't like being attacked an officer or anything like that. On that one, and then we go on down to another Bledsoe, 168-3839. The victim was attacked with a closed fist, punches, and kicks, and they took 6 months, and I think 6 months sentence credit reduction is deserved on that one, instead of just the 2 on the matrix, even though he didn't have any priors on that. So I made that one 6. Then we go on down to Northeast, number 168-6667. This even said in the instance that the video that stabbed multiple times in the back and had serious injuries, and the sentence reductions should be at least 18 months. Now that's the next 3. They were all involved in this, and the video shows that they were all doing the stabbing and everything. And why they only took, I mean, that's sometimes if they would explain this to us, they took 4, 12, and 4. So I went up to 18 all of them because they video evidence that they've stabbed the man repeatedly times. And then South Central, 168-5308, the victim was beaten with a broom handle, and the swelling and bruising on the left side of the jaw and the scapula, and the sentence reduction should have been 15 months, I say, instead of just 5 on that, because that was a pretty hard beating. And then at Turner Center, let's see, 168-6063. The inmate grabbed an officer and pulled inside the food service where they put the food tray in, and then attempted to take something. What had happened, an inmate had tried to throw some contraband to another inmate, and when the officer picked the contraband up, the inmate reached out of that and grabbed the officer's hand, tried to pull it back in so he could get the contraband back away from him. And so I was going to make him pay more for that, because he was trying to get his contraband back and not let the officer have it. And then what's that TC? I forget what that is. That's
Turner
Attorney
Center.
Center. Yeah, Attorney Center. I get them mixed up. Attorney Center, 168-5616. They punched the victim in the face, causing nose and lip to bleed. Sentence reduction should be at least 9 months. They only give them, I know it's only one prior, but I give him 9 months because he made such a awful thing on the person. And then on West Tennessee, 168-5821, the video shows the inmate hit the victim in the head and the face with a fist, and so I took it up to 6 months instead of just the 2, even though he didn't have any priors on that, because that was physical violence. Does anybody want to say anything about those there?
Dale, I've got a question if I could. On
Okay.
the Northeast Corrections, the 1686667, the three AOWs.
Yeah.
They got, they all three got 24-month sentence extensions. Did you know that?
No, I didn't realize that, huh?
They all got 24-month sentence extensions and referred to prosecution by the warden. The first one, the first inmate actually has an 85% for 8 years at 75% sentence that's flattening out. The second one, is already flattened out his sentence. He's, not getting any further, and the third one's doing life without parole. So I was wondering if, on those you would consider going with the D board, since they actually are getting 25 and 26, 7 months apiece.
Can I ask a question about that? So this is a question we've kind of struggled with for the last 18 months. Are we supposed to look at how much time they have to apply this matrix? Or are we supposed to apply the matrix based on the circumstance of the incident?
Each case should be by the circumstances of the incident and only the incident, if not what they're serving time for.
So the matrix says for an AOW, you can go up to 24 months. And I don't know with these particular ones, why the D board chose to take 4 months. Dale, you said he was stabbed repeatedly?
Yeah, that's what it said. And of course, I don't ever look at the time that they've got or anything like that. I just look at the incident, and then I go from the matrix. That's the way I do it. And then I seen all three of those. Of course, I had a lot of bad violent things this month, but they were all stabbed, and it says they were all doing the stabbing is from what I understand. And that's the reason I went 18 months on all of them on there, because I didn't know what all the circumstances was, and I just looked at the incident.
Yeah, the sentence extension actually was on the sentencing page. You look
For
at the
this,
LPP,
for
yeah.
this incident.
Then
So
going back through the blue. it
for
showed
public
up.
record again, what does a sentence extension actually mean?
The warden took additional 24 months away.
Of sentence credits
Sentence credits.
were taken away.
Right.
So, yeah, I think this would be helpful for us to be able to identify that. Can you help us, the rest of us board members, understand where should we look to see that? We can take that into consideration along with, because it's not, there's no instructions about it on the matrix.
Right. This one actually, these were showing the sentence extensions. When we're looking at the offense, you go from detail to sentence, and then you've got appeals. And when you click on the sentence, usually the first one's a fine, and then it'll have the LPP and probation. This one was notated in that section, 24-month sentence extension by warden.
Okay.
So it's in the sentence page.
Yeah, and just to be clear, sentence extension
Yeah, it's not a good word.
translates to the warden took away 24 months of sentence credits.
Correct.
Okay.
Yeah, because the warden.
That's helpful. Thank you
technically
so much
extended.
for that.
You'll have to help me with that too, Chairman. But so what you're saying is he took 24 months, and then they're going to take another 4, 12, and 4. Is that right?
Yes, sir. Yes, sir.
Okay.
The
Well, I mean,
D-board-
if that's the case, then it's up to the board if they want to do that then. But that's fine with me. I mean, if he actually took the 24 months and then plus all this, I mean, I just didn't really look at that. So we can do that. Okay.
Yes, sir. And he is included, all three of them are on the quarterly prosecution list. They have been referred for prosecution.
Did he
Okay.
do that after the keyboard or before? Or?
This one showed up, I guess, as part of the D board because it was in the sentence action. It was in there, the notation.
If it's not there, sometimes is it in a different place?
It's in sentence attributes. You have to go to the very back.
We'll have to get with that. Okay.
Let me ask, because we're looking at the one case where the first one, which, the Thomas in 6-1, just so we're all on the same page, okay?
Yes,
There's one prior, and so 4 for the D board falls in the matrix for one prior.
Mm-hmm.
Now, down 2, to the one that's Thomas ends 11-11, or just 11.
Yeah.
Here they have 2 prior. Well, 2 prior would not be 4. So that's out of the matrix. 2 prior would have to be 5 through 8.
Where's this, Mary?
On Dale's docket,
I mean, which,
northeast, look at, you see
Northeast.
that 3 AOWs?
yes,
And Dale was asking for 18, 18, and 18, right?
Right, that's
Before.
what I asked for.
Chairman. So following the matrix, the first one had 1 prior. So assigning a 4 by the board is within their matrix. The second one had 3 priors, so assigning 12 is within the matrix. But the third one has 2 priors, assigning 4 is not in the matrix.
okay.
So it should be 5 to 8. So at a minimum, that one should be brought into compliance with the matrix.
Let me mess up the equation even more. Actually, the first one that ends in 6-1, it's showing 1 prior. And 4 months taken, he actually had 2 priors taken.
Oh, he had 2 priors as well.
Yes, ma'am.
Okay, so he should be 5 to 8 as well.
Right.
So, Mr. Carter, how do you want us to?
Well, I want,
Andrew.
if that's the case, and since it's got the 24 months, and if I can be sure he's got the 24 months off of that, we can go to the, I won't make too much of a difference there on the D board. So let's just go to 5 and 5 on that one. And, on the, 61 and the 11, let's go to 5 and 5 on the D board, or go up one more on that one, and then leave the other at 12, and then with the 24 months, that should even it out, and we'll be in the matrix then. Okay.
Yes, sir.
Just
Hey, and Dale, and I'll say this for everyone, one of the things we learned, and I don't know if you can see, I'm holding up the matrix, the new matrix here.
Yeah.
In the scan that we're gonna start receiving, and every D board now, the DHO is required to fill in why he took the amount out, and like there's sentence extensions that'll all be written, and we'll be able to read it. So
okay.
they're doing a lot of things to make it more efficient for us.
Just so everybody knows, there's a
Good,
copy of the tab 3, if anyone needs it.
Okay. So, if that's okay with the board on that, then could we just do, where that says 4 and 4, just go up to 5 and 5? Leave that 12 where it's at?
Yes, sir.
I mean, it's up.
Do you want to go through your restoration docket, Dale, or do you want to do a motion on your withdrawal docket?
No,
first?
we'll go through the restoration docket too. Okay. Okay. Then on that,
I'm sorry.
Are you not
Go ahead.
tracking?
Yeah, I'm tracking, but there's some that are not in the matrix that I've got a problem with. Like the AOO, if there's no injury, let's just take West 10. He had 0 priors, the D board took 2. And you took 6. That's not matrix at all.
What were the injuries, Mr. Carr?
let me see. Let me. Which one are we
third
talking
one.
about?
I mean, it has to be serious injury to go outside.
Let him find which one we're talking about.
Okay.
It's the third one from the bottom on the withdrawal. So it's West 10, incident number 1685821. That's the one Mr. Frank's talking about.
On the withdrawals,
Yeah,
168. What now?
1685821.
Is this on my regular docket or my restoration docket?
Regular docket.
Oh, what? Okay. Okay. 1685821.
Yes, sir.
Three up from
I'd
the
have-
bottom.
Yeah, I'd have to look that up and see.
You read it out.
Let's see.
You read
One
it
six eight
out.
five eight two one. Right. That's the one. I've got it here. I've got that on my. The video shows that the inmate was hit in the head and face with the fist and a six and made. Well, I put it in because he hit him so hard with the video shows inmate hit victim in head and face with the fist and was very violent with him. So I went out. Maybe I did go outside the matrix. No, 0 priors, but they give him 2, so I give him 6 because of all the violence. So, and y'all can talk about that one too if you want to. I'm just trying
Actually, you think there needs to be a?
Well, I
injury
mean,
shown?
it's very clear to go outside of the matrix, which is 0 would be 2. There has to be serious bodily injury. That's not, and if the guy didn't go to the hospital, that's not serious. Did he go to the hospital? Was he checked in?
didn't say. It just said he hit him in the head and face with a.
Here's how I go about it. If you look on the sheet right off the bat, it'll say either 0, which is no injury, or 1 is minor injury, or what is it? Is it 1, 2, 3, or I'm trying to remember how they do that. And then the last one is serious bodily injury. Those are the only ones I ever considered that you can go outside of the matrix, serious bodily injury.
So I think for me, it begs the question. I understand it's TDOC's matrix, and I
Yeah.
understand we're confirming whether or not they're complying with their matrix. But are you saying that as board members, if our opinion is that it's violent, we have no say on how we request on our docket for time to be taken, that we can only say what's on the matrix?
I mean, by what what council had stated was that we can. I mean, and TDOC said we can, but then at that point for their due process, we have to have our own hearing. We have to do this over again. And we're not equipped to do that.
I'm not.
We cannot use their D-board hearing to do whatever we want to do. We would have to set up our own hearing to do that. If we go outside of the matrix, we're going outside of the matrix. You can't get a little bit pregnant. If we do it, we do it. And I'm of the firm belief that we stay inside the matrix.
Well, and we have a difference of opinion, and I respect that's your interpretation of what we've been told, and I know we're in other discussions about that, but in this case, we're not talking about going past the 24 months. We're talking about whether or not an offender using closed fists to batter a fellow
But that is
offender.
but if he has 0 priors, that is going outside the matrix by the very definition of it.
Well, that's going out outside of a portion of the matrix, and I don't. I just-
Yeah, it's applying the exception.
Yeah, it is applying the exception, but I guess the more fundamental, I think there are some differences of opinion, because you're going to see some on my docket. My docket's coming too, where, I have opinions about if you put hands on a fellow offender or on a staff member, depending on how you did it. I don't feel like my hands are tied to,
Then we're not using their
months.
matrix. We're not using their matrix.
Well,
I think there's exceptions.
Well, I think, and also, I mean, I think this particular incident, the discussion is, I mean, apart from like the broad discussion, but for this particular discussion, the question posed to the board members, because this is our process, is everybody comes together and decides whether or not the interpretation by the individual board member is going to be accepted and granted by everybody. So the question for this particular incident is, does a closed fist punch constitute serious bodily injury?
Not legally.
Okay, well, I mean, and whether your interpretation is, does it fit the legal definition or your interpretation fits, personally, do I feel, that way? I think that's the question that's being posed with that incident. And so there's really two ways forward. The first is, we can throw it back to Mr. Carr. And Mr. Carr can say, you know what, I want to give everybody a chance to review the facts of the incident before they have to vote on it, and we can hold it over to the next meeting. Or everybody can just vote now on whether they accept that incident, or whether they accept the entirety of the docket. But either way, let's pull that incident out and let's ask ourselves the rest of the docket. There's that incident that we'll continue to discuss. Are there any other incidents that we want to pull out and continue to discuss the individual facts? Is that the only one that you saw?
No, I mean, I'm looking here at the second one on Bledsoe. Once again, 0 priors. Igor took 2 and Dale took 6.
Okay, so there's that second one from the top also. Are there any others that you identified as those that you'd like to pull out and really, really discuss before we vote?
We've already discussed this all. It was the 3 AOW.
Yeah, but I think we resolved those.
We resolved
Yeah,
those.
we're gonna change the 4 to the 5s on those. So those we resolved. Any others that are unresolved? So that way we could at least vote on the rest of that withdrawal docket.
Yeah, just make a point before we go, before we proceed. Serious bodily injury is not only determined if they're transported outside the facility or not. They could be seen by inside medical at each facility. And a lot of inmates often refuse to be seen and claim they're okay when they're not. And I'll ask you this question. Have you ever worked a homicide where the offender only used his hands? I have. And hands can be brutal and deadly, even though it's not considered a weapon legally for an aggravated charge as a weapon would be.
I mean, I realize you've worked it and that's perfectly fine.
But what
I
I'm
was
saying
told
is-
by counsel that we don't go outside the matrix on our own. That's how I feel.
And I'm telling you,
I'm
there are
just telling you, that's
injuries,
how I
there's a
feel.
possibility for injury that exists beyond what you know.
And at that point, we can have our own hearing and give the inmate, if we're going to not use their matrix, I've been told that we need to do our own hearing, and I don't know if I know we're not equipped to do that. So anyway,
Well, that's what I'm trying to understand first. Are there only those two? Are there only?
Let's
those two?
take,
Well,
let's
okay.
take those 2 out. We can vote on the rest of it, and then we can go back and vote on those.
Okay, that sounds good. But before we do that vote, Mr. Lindsay wanted to make a comment about the AOWs we were discussing.
Being uniform, just being uniform, they were given the matrix, they gave them 4 when they should have gave them 5. And we wanted them to come up to the matrix. What I'm saying is, do we want to marry the matrix only when they go under? What discretion are we giving them? It was 5 months by the matrix, but they gave 4, and we wanted them to go up in the matrix. Now, Lee is saying,
I would go 5.
you're going out of the matrix. So I just want to know, are we going to stay in the matrix or are we going to come out of it? Because I don't want us to, and everybody's can go at it their own pace, but we only go out of the matrix more times than not when it's taking more time away. And that's what I'm saying. When the AOW, when they gave them 4 instead of 5, we were like, they wasn't in the matrix. They were not in the matrix. They were supposed to have 5. Granted, that's fair.
Or 8.
Or they were supposed to have 5 months. Keep them in the matrix. Now, when we go over and it's like, you get more time, well, then we can go everywhere with the matrix. So the matrix is just like a loose fumble sometimes in here. It's whoever can recover it when it fits what they want it to fit. So I agree. That person, he or she was supposed to have 5 months taken. They only gave him 4. We brought him up to the matrix. Now we're in a different case and we're out of the matrix, and that's the way we're applying it's not there anymore. So I just want to get clarity. Are we gonna stick within the matrix or we're not? Because if we're gonna go back and forth, then we should go back and give those people 4 months. It's like when we're taking away more time, then the matrix doesn't apply.
Well, I think one interpretation, one answer to that question is we're staying inside the matrix unless we're applying an exception.
Exception, okay, that's
So
fair, he
if
did say that.
you're not applying an exception, then the expectation is that you will remain within the guidelines.
Okay,
And now for those two that we're gonna take out, we're just trying to understand whether or not that exception actually applies.
If you're talking about the last exception, and you can take it however you want to Mike Ward. And he said, yes, you can use that exception. Our D board, if they go outside of the matrix, has to show the exception. He said, but then you have to have your own D board and you come up with the exception. He said, you're trying to piggyback off our D board hearing and do your own matrix. You can't do both, is what, that's my interpretation.
Yeah, and
So
that's
how
a fair
I
point.
believe.
That's a fair point. But
I certainly respect Mike Ward's opinion on that. But I do think that the board has statutory authority. And the way I look at it within the matrix is the matrix does set the upper limit at 24 months.
yes, ma'am.
And so applying the exception, and I'm only speaking for my docket, which hasn't come up yet. When I apply that exception, other than for one case, which we've held over, and I'm just putting it on my docket because we're continuing to hold it over, I'm staying within that 24 months. So to me, that is staying within that matrix because I'm not going outside of the 24 months, but their own matrix has room up to 24 months. And I don't agree
For
that,
certain cases only.
yes, I understand that. But I don't agree that to go up to that 24 months, we would have to conduct our own hearing. That is the sticking point for me because the exception up to 24 months is written into their own matrix. So why would we have to do another hearing if we were going to use that exception and go up to that 24 months? So I think
Is it an AOW?
well,
What
let's
is it?
let's
Okay.
let's
Okay.
pause. Let's pause
Okay.
for just 1 second because this is a substantial discussion and we can at least clean up a little bit of this before we get into that substantial discussion. And I think we may even give Mr. Grauberger an opportunity to say some things. So we're taking away the second one from the top and we're taking away the third one from the bottom. Okay, we're gonna take those out. As for the rest of Mr. Carr's withdrawal docket, we can entertain a motion to accept those for further processing through action. We have a motion, seconded. Any discussion on that? Just those cases that there doesn't seem to be any discussion on. Any issues with that? Okay, so just a vote on those cases. All in favor, please say aye.
Aye.
Okay, all opposed? Okay, so that passes. So now we're pulling out two. And we're gonna get to those two. I promise we're gonna get to those two. But let's just finish up with the entirety, the rest of Mr. Carr's docket. Let's just finish up the restoration docket. Mr. Carr, I did see that you had sent me one change for your restoration docket. Is that correct? You're taking out
That is correct. Mhm.
one incident.
One.
So the incident that I saw you want to take out is the second WHK from the top out of Morgan.
That's right.
The last Morgan case, we're taking that one out and the rest of your restoration staying the same. Is that correct?
That is correct. Uh-huh.
Okay. Are there any of those cases you want to talk about?
Is it 50/30?
Yes.
Well, just the last one, there, the attorney center, 1684970. The D board took 12 months, three priors. They did take 12 months. I was only going to take 9 and give him back 3 because when I looked at it, all he did was when they give him his pill, he spit the pill in his pocket. He didn't take it. So I didn't think that should be the full length of the whole sentence. I mean, I don't know why he spit it in his pocket. Maybe he won't take it or just didn't. I don't know. But that's the reason I changed that one. And that one was questioned a little bit. But anyway, with that, I'll stand on the rest of them on that,
I'll make a motion to accept the removal.
Okay.
Restorations.
Okay, seconded. Any discussion on the rest of those restoration incidents? Okay, all in favor, please say aye.
Aye.
All opposed? Okay, that passes. Appreciate that. Okay, so we have two remaining cases on Mr. Carr's docket, the two we identified previously. We're sort of discussing the issue of applying exceptions to individual incidents. This is a good and substantial discussion. We have two choices at this point. We can either continue to discuss this now and resolve these incidents moving forward, which may have larger implications. Or we can choose to defer these cases and schedule an executive session with our attorney to discuss how exactly we want to approach these cases. What would be the preference of the board? To resolve these cases now or to defer these cases until after an executive session where we can talk more about these issues?
I think they can be resolved.
I think they can be resolved now. Okay, then let's talk about them now. We basically have a
Could I
situation.
offer maybe a third, and that's that we get through the dockets and see how many of these, because I may have some of these on my docket
Okay,
as well. And let's just discuss that whole pile together.
okay. I just don't know how many. I mean, if we have several, we'll be thinking about several. What would everyone like to do? Would they like to resolve the entirety of Mr. Carr's docket or continue with the agenda and then do all of the questionable incidents at the end?
I like to resolve.
I think on Mr. Carr's,
Well,
pretty
just,
quick.
yeah, so I'm hearing most of the people would just rather get these two out of the way.
Goodness.
Okay, so essentially the question with these incidents, and here's what we'll do. Mr. Carr, I'd like you again to just talk through your thought process about why you decided to apply the exception to these two incidents. Then I'd like to open it up for discussion, and I definitely want to give Mr. Grauberger an opportunity to offer his thoughts. I think he has some. So just again, to be clear, these are two assaults, one of which was a closed fist hit, and what was the other one? What happened in the other one?
The first one, Michael, was on Bledsoe. The victim was attacked with a closed fist, punches, and kicks. And so I thought that was a pretty extreme thing. I mean, if you hit a guy, then you get him down and you start kicking him, that's even more force with a leg than it is with a fist. So that's the reason I went up to 6 on that one. And then on the very bottom one there, the video shows that the inmate was hit in the head and face with his fist. And I just applying the same thing too as the one up there. They were hit hard and as a physical contact. And I was thinking that 2 months probably would not, in my opinion. I know that's a matrix, but in my opinion, it wouldn't have much effect on it. You know, I hit a man again if I only took 2 months off. So I was going to take 6 months off and make sure they know that we mean that this violence has to stop, because I had a lot of violent cases this month. And then I want to explain. Go ahead.
Yeah, I'm sorry. No, go ahead. I'm sorry.
No, though, that's all I got to say on that. I want to say another thing or two, but it's concerning some other stuff. But go ahead. Y'all can vote on those two right there, and how the board votes, that's entirely up to the board.
Okay, so the exception that you're applying is the one that allows for an increased sentence withdrawal up to 24 months for serious bodily injury. Is that right,
Yes.
or is there a different exception?
Yep, that's basically what it would have to be.
Okay, so we heard from previously whether or not those facts maybe rise to the level of serious bodily injury. So as we think about that, Mr. Grauberg, did you have some thoughts on what the board
I
members?
do have a couple of thoughts.
Okay.
First off, I think somebody mentioned that there is a delineation as to whether the injury is, if it's serious or minor or no injury.
You mean inside of Thomas?
Yeah.
Okay.
So there should be one clue, but the other.
Well,
thing-
let's unpack that for a second. Mr. Carr, was there any indication inside of Thomas that indicated the level of injury for either of those cases?
I don't remember. That's all I put down for my explanation that they was hit with closed fist on the first and kicked. So a kick is definitely hurting. I mean, I don't know.
Hey,
I don't know if I
Dale,
was any.
Dale,
Yeah.
I've got your Bledsoe one pulled up. Sorry to interrupt you.
Okay.
And on the detail page where it says level of injury 1, it says no injury. I'll look at the other one for you in just a second.
Yeah, I'll look at it because I'm just trying to look at
Yeah,
it.
so that gives us some indication as to that. What was your second point?
Yeah, my second point is serious bodily injury is the result, not the method.
Okay.
So I think it's improper to say because you used your fist or your foot or that's automatically serious bodily injury. It's not. It's an awful thing to do to someone, but I think it's the result, not the method.
Okay,
That matters.
okay, we appreciate that.
So I'm looking for the language on the matrix for these words, serious bodily injury.
See, it's in
And so-
the AOW.
Yeah, I'm
I mean,
looking
exactly
for those
this.
words. What I see is serious injury
Serious
Okay.
injury.
up at the top, but then at the bottom, under the word note, it says the imposition of a harsher penalty shall be sustained only if the offense involved a death, assault, or injury. Now, to me, I would read assault or injury, meaning an assault in and of itself occurring.
The rest of that phrase is assault or injury to an employee.
Well, and I understand it says to employ, volunteer, or visitor. And when we met with Linda Thomas, I asked her specifically, did you intentionally omit the word offender here? Do you mean that offenders are not going to be protected in the same way that staff, volunteers, or visitors are protected? And she said, oh, absolutely not. The word offender to any human should be here. And so that's the interpretation that I'm using, that there's an assault. It was an assault on a human. And so there's the possibility, although not relevant in all cases, for the imposition of a harsher penalty. In absence of any documentation of a severe injury, it says assault or injury, not serious injury. So I recognize what it says up top, but I have to read the entire document. And so I'm reading at the bottom of the document as well.
Well, there's 2 points to that. I think we have to be careful to not say that I'm reading it very closely because this is what it says, and then in the same breath say, but I was told something different. And so, I want to be careful about doing that, but then also, and I do think it's important to go, I think the issue that we run into, and I think it's a good one, and this is why it might need more discussion, is we have to be careful not to cherry pick pieces. The rest of that really hammers home the point that I think Mr. Frank is bringing home, that all of that note is dependent on the disciplinary committee's findings. And so I think the point that's being proffered is that if the findings themselves don't support the decision that we're making, if an interpretation isn't necessarily supported by the evidence that we're provided, we can't point to the evidence that shows why we're making a different interpretation, then the result should be that we develop new evidence that supports that interpretation. And so if we rely on that note as an exception, then the entirety of the note applies, which includes what part of the findings are we using to support the exception that we're finding. And so
To that point, I heard Mr. Carr say that he based it on the fact that the person was assaulted or kicked or something with a fist.
And that's what I think sort of gets down to. Is that enough? For some people it may be, and for other people it may not be.
Yeah.
But let's not confuse the idea that we're going to rely on and use the facts that are presented to us and in other cases, not use those facts, sort of develop and interpret something else. If we do that, then we really do need to develop those facts independent. So we're kind of confined by that, but that's why, to the chairman's point about looking at the ledger and seeing, was there a designation, a zero designation, one designation? What was the extent that the committee found with regard to the injury? And sort of incorporating all that. Yes, we'll let you go. And then, Mr. Sharon, your hand was up and it went down. Did you have something else to add?
Yeah, sorry, I was text. The first case or the last case at West Tennessee State Penitentiary. That one on the detail page lists the level of injury as 1 no injury. Just for Dale.
Okay, all right, thanks. Yeah, please.
To add to Mr. Sharon's, no injury on Bledsoe, I'm looking at the incident report, and actually this incident occurred on August the 1st. And they did an investigation, and it was written up August the 5th. It was 2 females that got into the altercation in it. And the last part of it, it says that the one female, kicked and punched, the other offender never tried to retaliate. And there was neither offender showed or reported any injuries to medical after the fact. So there was an investigation done by what team do you call it, Mike?
It'd be the institutional
Yeah,
investigator.
just institutional investigator. And they're saying there was no injuries, which 2 women, that's the worst fight you can get.
All these discussions will be helped by the fact that TDOC will be scanning us documents from the hearings in the future.
Yes,
That'll help out a lot.
yes, it will, for sure.
And we do have a third alternative that we could refer to the incident back to
Yes.
TDOC and let the commissioners designee re-review the case.
Okay, okay, so.
Vote on it. I mean,
So, yeah, we have a couple of choices. I think, one, we can, have Mr. Carr, it's his cases. Do you want to change, anything or based on that discussion? Or do you want to move forward on a vote with, what you have presented?
Well, you know me, I like to, well, what about, I don't want to re-refer it back because that would just be that much more time. I think everybody is, except maybe, me, it's come up the fact there was no personal injuries or anything on that. So, I don't know. Let's just vote on these 2, and that way I'll take this all under consideration and maybe work out better the next time. But that's the way I was feeling on these, so I want to sort of stick with that. Okay.
Okay, so, I would entertain a motion, to either, just a motion to approve, the cases as presented, and the results as presented by Mr. Carr, or a motion to refer the cases back for further development to TDOC. If anyone wants to, or, we could do a motion to deny. I'll just entertain a motion,
Yeah.
essentially.
I'll just make a motion that we accept and approve these 2 cases, and you can either vote yay or nay on that.
Okay, do I have a second?
I'll second that.
Okay, seconded. Let's do a roll call vote on these 2 cases. Chairman Bassbinder,
Nay.
Mr. Frank,
No.
Mr. Carr,
Yes.
Mr. Lindsay,
Nay.
Ms. Doyle,
nay.
Ms. Wiseman,
Nay.
Mr. Sharon,
Nay.
Mr. Dunn,
Yes.
Ms. Carpus.
Yes.
Okay, I've only got 3 yeses, so motion fails. Okay, I really appreciate that. I think that's going to be helpful moving forward. I'm sorry. Yes, Mr. Carr?
Okay. No, I will look at everything very, very close next time and see about that. And I'll try to get my mind wrapped around some of this stuff. Okay. Can I have just another minute to discuss a couple other things I've seen on this docket?
Yes, yeah, please do. I want to give everybody a chance to kind of talk about their themes and anything else that they noticed this month. So please.
Well, of course, a lot of this was
Or we can just take it off.
Trousdale. But anyway, I was concerned about, I found out a lot of what I thought was the serious assaults were being dismissed, like on, at Trousdale, we had one, incident 168, 168, 5952. The video showed lacerations and puncture wounds, and this inmate had two knives. That was dismissed. Another one at Trousdale, 168, 592, the same thing was, the two people was, video it shows lacerations, puncture wounds, received outside medical evaluation. That was dismissed. Then two more, Trousdale. I'll just put on our video showed that the lacerations and puncture wounds, but they dismissed the hearing. So they're dismissing some. Maybe it's just Trousdale. I don't know on that, but okay. Then we had a couple on one on Whiteville that held the victim against the will with a forearm to the throat. Well, they dismissed that one. And then I wanted to go on down to and discuss too what I found out on some other things down there that they had these as A's and they reduced them down to B's. Was one at West Tennessee. The inmate was squirted unknown liquid on the leg of an officer. We don't know what that liquid was, but we could figure out what it was. And then this one at the Northwest here, they had an instance where they found like 62 grams of meth and some heroin. And of course, that's a lot of stuff like that. And they reduced that to a B. South Central reduced one to a B where it just scratched the officer's hand through the foot port there on the cell door. And then the other one from South Central, video showed that the officer was pushed and the torso and pushed back. They reduced that from A to a B. And then also on Trousdale, the cellmates were fighting and the victim had swelling on the left with his forehead, and they reduced that to a B. I'm just wanting to show you a pattern I'm seeing on that they're dismissing quite a few, and they are reducing a lot of them down to a B. So we just need to look at that, and maybe we can talk to the gentleman that was here today on that, and we can get some further clarification on some of that.
Yeah, absolutely. I really appreciate those. If I didn't catch all of those, but maybe you and I can talk offline and you can give me those examples again and we can reach out.
Yeah, I can send them to you. Yeah. Mm-hmm.
That would be really great. And I can get those over to corrections and ask them for some more information on not just the trend we're seeing, but the answers to those individual incidents. So that's great. I appreciate you identifying those for us and getting that over to me. So thank you for that.
Thank you. I'm through. Thank you.
Okay, great. Well, we appreciate that. Thank you very much. Let's move on to our next presenter, Mr. Frank, I believe.
Yes, thank you. My modifications are added 39 months and gave back 16 months for the month. Pretty straightforward. The institutions seem to be getting better and better each month. And speaking with Mike Ward, and this is and Betsy, I'll tell her in a minute or later, that he is personally, I guess they've given him the responsibility of cleaning up the matrix. He's talking about very soon when I talk to him. He said once the commissioner signs off on it. So I think that it's going to be something I'm anticipating that is more to there'll be some different exceptions and different things like that. So I think that he understands what we're trying to do and certainly what they're trying to do. And he just seemed excited about it. So I just wanted to pass that on. I was like, you talking about like in spring, and he's talking like in the next month. I mean, that's what he told me. He said, you know, I've got 6 or 7 that I'm working on and I'm whittling it down and I'm almost there. And then I'll take it to the commissioner and then go from there. That will take care of, Mr. Sharon and some of his confusion.
I can see you.
I'm having to laugh at
I'm
that.
just kidding. Mike's the GM. But he said it's just we're having some issues still at different institutions that look at things differently. So anyway, that's all I have is that, I think that this will be coming soon. So if there's any questions on mine, it's,
Yeah, any
it'd
questions,
be more than
Mr. Frank?
And I will say this as well. If you ever see something, you're like, what are you doing here? I don't understand this, or this is wrong. Feel free. I want to be correct. And if I've missed something, please reach out to me. That's how I feel. Because we want to do what we're supposed to do and be precise and let people of Tennessee know that we're doing it right. So if there's ever that, when we're doing this stuff, we don't have robots doing this. We're doing it as humans, and there's sometimes human error. So feel free to reach out to me.
Motion to accept.
Seconded. Any discussion? Okay. All in favor, please say aye.
Aye.
All opposed? Okay, motion passes. Thanks, sir. Any closing remarks on tech trends or any issues? We heard from Mr. Carr, an uptick in violence. Anything you saw similar to that?
There's something that's on the horizon, and I don't know if this is going to be handled. It's probably something for us to discuss. It has to do when there's an AOW, a PGA, and a knife. Jerry, you can help me on this. That's something they're working on, I know, in Nashville.
Okay, but any trends or anything on your cases that you saw this month, similar to the violence that maybe we saw a little more of?
There are inmates. This is what I do believe while we're making such a difference and TDOCs, as we move through the months, are getting better and better, I believe. The institutions are. Is that exactly, and I told Senator McNally this, I've told him several times, is that Lieutenant Governor, excuse me, what the legislature wanted to happen, the violent inmates that are prone to be violent. We don't have a crystal ball. There could be an inmate, and we've seen this before. Jerry and I have talked about this case, had not a write-up and got out and committed. We can't deal with that. That has to do with the judge sentenced them and this, there's nothing you can do about those situations. If we're not going to keep people in prison forever, they do get out, they can do things. But the ones that have proven to be antisocial and violent and addicted, that they will, as we can all see, we'll be flattening their sentences out. And I think that's what they wanted, is that we're going to keep you in as long as legally possible. And you won't be paroled, and you won't, hopefully that'll be shown that we're protecting the citizens of the state of Tennessee. And I think we're going to really see that in the next 6 months. It'll be very evident, the ones that are not going to be out.
I think it already is. That's great.
Anyway, that's all I have.
Okay, thank you. Well, let's plow on. Chairman, I think your docket is next. Huh?
Yes, sir. I had 220 total cases for the month of August. Out of those 220, there were 111 that were okay, 18 not okays. There were 26 Bs, 51 dismissed, and they're getting much better on some of the dismissals. Notating procedural error or rewrite up or, why it was dismissed, which when we get the new program, that's to solve it. I had 14 others, and the others I put in were rewrites or someone started out filling out an offense report and then just had to stop and it timed out and there's no information, or it was a knife and a pounding ground. But overall, there were 953 months taken by the state D board. I'm asking to add 31 months onto the offenders, and I'm giving back 26 months, which will end up dropping the total to 958 months for August. On that, I had one case out of 220 that was appealed, and it was denied. So that was my August cases.
Thank you.
Motion to approve.
Second. Any discussion on Chairman's docket? Okay, hearing none, we'll move to a vote. All in favor?
Aye.
All opposed? Okay, great. Thank you, sir. That's awesome. All right, moving on. Our next presenter is Mr. Lindsay.
Yes, sir. The D board was at 106, had 93, credits lost or removed and granted, 33, returned 33, if you will. So, it was a modified mine, to 93 and returned 33 months back.
Any incidents you want to discuss further, highlights?
No, I see the effect of the board. When you, just going back to the beginning, when we started, you can see the work of the board, and not that they're all spot on, but you can tell our recommendations, our work has been heard and been noticed with them trying to get close to the matrix or being spot on the matrix. So kudos to everyone in this room, from Tammy all the way to our executive director. You can see, just if you were here in the beginning, from what the incidents and the reports used to look like, and then seeing our recommendations and looking at it now, you can see improvements with not all, but most of the facilities. I ain't gonna highlight none, but most.
Okay, great. Okay, well, I'll entertain a motion to approve the docket.
Motion. Second.
Seconded. Any discussion on any individual incidents anyone sees they'd like to talk about? Okay, anybody? Hearing none. All in favor, please say aye.
Aye.
All opposed?
Aye.
Can I make one observation, a trend that I've been?
Yes, and I was actually gonna go back to, I don't think I gave you a chance to do that, so please, yes.
The trend I've been seeing, and I don't know if anyone's noticed it, but on the DA referral, there are a lot of misconducts that are being prosecuted as indecent exposures. And while we were at TDOC last week, I talked to Mike Ward about that. And what it is, in the old days, the old guys that have been working at the prison, indecent exposure was sexual misconduct. So a lot of them still have it in their mindset when they go to do their report, sexual misconduct, but they are catching it and they are prosecuting it, because if you've looked at the referral, they are prosecuting sexual misconduct as indecent exposure. But it is a glitch. TDOC is called, but they also are catching it and referring it. That's something I had known.
Great, good to know. Okay, thanks for that. Moving on, Dr. Carpos, I believe your docket is next.
So I reviewed 216 individual inmates who had received a disciplinary. And of those 216, 32.4% I found were in compliance with the TDOC matrix. So that was a total of 70. Similar to what Mr. Carr spoke about, I continue to see quite a few numbers being dismissed. And so in this case, of the 216, 62 were dismissed, which is 29%. And then for those to look at on the docket, I had a total of 51, which is just over 23% of the cases would appear on my docket.
Oh, I'm sorry, what percentage was that?
For which one?
The last one that have appear on your
Well, it
docket?
was 23.61%.
Oh, 20. Well,
So any questions about my docket? I identified 340 credits, monthly credits, that the D board applied. My analysis resulted in 530, which is a difference of 190 credits.
Did you want to talk about what we were talking about before the meeting, those block of cases? On the
Sure,
second
yeah,
page.
yeah. But do you want to vote on my removal?
Yeah, it's up to everybody.
Motion to accept.
Okay,
I'll second.
okay. Any discussion on any of those cases? This is just the removal docket, right? So just that first page. Anything on any of those incidents?
No, it's just as a note to Dr. Campos, which she bumped some of her, indecent exposures up to 24, which is in the matrix. They are prosecuted. They're on the prosecution.
Well, and maybe you're looking at the one in particular at Riverbend where he has 10 priors. Most of those are indecents. And the D board just, for the indecent, just before this one, they took 24, but why they went down to 12, I don't know, but I put it at 24.
And all those are still pending. Because they're so.
Okay, all in favor of approving that docket, please say aye.
Aye.
All opposed? Okay, motion passes. Thank you.
And then I just have a real short restoration docket. It's only 3 for a total restoration of 4 monthly sentence credits.
Okay. I will entertain a motion to accept that docket. A second, seconded. Any discussion on any of those incidents? All in favor?
Aye.
All opposed? Okay, that passes. Thank you.
Okay, and then I don't know if other folks have been seeing this, but I've started to see this, and I handed in 4 incidents that occurred here that I've listed as they're improperly coded. You know, on that one tab where it shows and identifies the offender and puts the word suspect next to them, or if it's a staff member, it puts reported by next to them. Well, they were actually inverted. And so the staff member was identified as the suspect and the offender was identified as the reported. So these, I'm just turning over to the executive director so that he can notify TDOC so that they can make those changes so that the disciplinary process can go forward, because the process isn't triggered because they were mislabeled. So I would assume I'll see those again. I don't know if will they be reassigned back to me?
Now that I've identified them, I will.
Okay.
Yeah, I
Sounds
can
good.
figure that out. As soon as we get an answer back that's been corrected, I will take them and I can just send it back.
Yeah.
In whatever month we're looking at.
Yeah. And then the last one is just the one that keeps rolling from month to month that we've been discussing.
Do we want to discuss that one?
I didn't necessarily bring it so that we could discuss it at this time. I just put it there because I'm maintaining those that are still on the roll.
Okay. So,
I think we have a lot of discussion with our council yet on that.
okay, so you're not asking to bring those for now.
No, I'm
Okay, so we'll keep that one there and we'll just.
So really
an
the
executive
restoration
session.
docket was it on this
Yeah.
page.
I was gonna mention something to somebody. I saw it on Heather's. And I've got one this month. No. Where a TSD was notated as a B and it's not in policy yet. And you had, that drugs can be A or B. So that's that. But there was something else, was RAA that they did as a B.
Yes.
That cannot be a B. So on that case, so the inmate's not confused and do we need to send that back to TDOC or just say you see what I'm saying? Because they're gonna be seeing it as a B. Does that make sense? It says it's a B, but by policy, it cannot be a B.
What do you want?
3 months?
I mean, we could just change it, say it was supposed to be an A. We're gonna take the right time. What do you think?
Change it. I think we change it just like we did on Jerry's from a long time ago.
We just change it and then if there's ever any discussion, we go, well, that was an A and your D board
My
basically the
humble
D board
opinion.
is,
Miscoded.
right, it's one of those that can't be either or, it
Don't
can
they
only
need,
be
don't
an
they
A.
need to send it back so they can change it?
Well, so really the two approaches.
That's the only thing I was questioning. what to do.
The two approaches would be that we let them know and then give them an opportunity to change it, or we send an action form that says, hey, change it.
Oh,
So it's really just in what way we want to communicate that message. So
but in the system, it will be changed.
either, the expectation is if we sent it back to them and said, hey, you guys missed this, they would change it, but there's just, it's really a difference between an email or an action form.
It was just an observation I had. I have two this month, actually.
Okay.
So I do have one trend I wanted to.
Oh, yeah.
Oh, I'm
We're gonna
sorry,
get back to-
Yeah, I won't move on, but, so what I'm hearing is for those, we'll just do a separate action form. And we'll just include that in our forms and say, hey, change this, we're not asking you to look into it and change it, we're just telling you to change it, this is what needs to be changed to. So that's the way we'll approach it.
Okay.
But yes, before we move on from Dr. Carpos, anything you'd like to talk about, you're seeing, facilities, uptick in violence, whatever?
What I noted this particular time, and this only dealt with, two separate core civic prisons. And I think Mr. Dunn might be able to help. We haven't discussed this, but my recollection is that the state of Tennessee devoted money to create a canine program for the Department of Corrections. And that these dogs are highly trained so that they can find contraband. They're trained to find drugs, they're trained to find cell phones, they're trained to find a variety of things. And what I noted in at two separate core civic facilities was the canines were brought in and they identified the contraband, and these cases were dismissed. And so in looking at what contraband the canines were able to identify in two separate one case at one of the facilities, the dog was able to identify, obviously the human wrote up the incident, but the dog identified a cell phone. And in the other one, let me see what the dog identified. Hang on. No, it was a cell phone as well. So, we know the impact of cell phones. And so I couldn't see anything in the incident as it was detailed that would help me understand why they dismissed it. But I would like to think that given the amount of assets and resources that go into acquiring, training, and maintaining, and if a CERT team went out to the core civic facilities with these dogs to do these searches, I would not like to think that they were dismissed, as we frequently hear, the employee was not available for the hearing. Well, obviously, those CERT team employees are not going to be available for the hearing because they don't work at that facility. They work for the department and are deployed all over the 14 facilities. So I would like to have some understanding about these dismissals, because if the assets are being put out in the field to do these searches, and then the end result at the D board is going to be, because we don't have the CERT team or the dog here to participate in the D board, then we dismiss it. That has me concerned.
Okay. We can check in on that. Now, you've been careful not to name the two facilities.
No, I haven't named them.
That's what I mean. Do you want to name them, or do you not want to name them?
I don't feel the need, because it occurs all over the place. I don't need to blast a particular facility. I do know that they are both core civic facilities.
Okay. Yes, we can try to get some clarity on those issues. So thank you for that.
Just so everybody knows what she's talking about, this TDOC, and I don't know if it's still under OIC, I think it is, has a strike force team. And that strike force has a number of officers and canine. They could go out statewide to any facility and operate a search, backup, whatever they're called to do. It's like the statewide SWAT team. Each individual facility has what they call a CERT team, cell extraction recovery team. That's all right. And every facility, and they're labeled something different at the for core civics. The name escapes me right now, but every state facility has what they call a CERT team. And that team, basically does the same thing on a daily level at each facility. But OIC assigns a canine to each facility, and sometimes that canine is shared by two different facilities. Sometimes, for instance, in Morgan County, Bledsoe being close to each other, and in Davidson County, a lot of times the canine will share the facilities. And they are trained, as Dr. Carpenter said, to find what they find. But it is difficult if a strike force team officer is credited on the chain of custody with finding a object because his dog, or he was a witness to the dog finding it. It is difficult to get them for hearing. And a lot of times the institution investigator at the facility will also second as a witness to participate in the hearing. So, but there's a mountain of stuff, factors that factor in that we don't see here at this level. So I just need to bring that up.
No, thank you. Okay, moving on. Mrs. Sharon, I think your docket is next, sir.
Great, thank you, sir. So for the month of August, the cases, I reviewed 159 incidents involving 259 inmates. I still have 6 as of this morning, still 6 of those incidents are still pending. I've sent in 13 requests for more information from TDOC about cases that were, in my opinion, improperly dismissed. They certainly dismissed more than 13, but that's just the ones I have questions about so far. TDOC, in my review, they removed 1,034 months of sentence credits, a little over 86 years on the cases I reviewed. After careful review, I found what I believe to be 32 errors on the different D boards. I'm recommending removal of an additional 215 months of sentence credits and the reinstatement of 5 months of sentence credits.
Motion to accept.
Second. Any discussion from anyone? Ms. Sharon, the only thing I would know is, I noticed on your docket, there's a lot of 0 sentence credits withdrawn. So particularly South Central, are you seeing just a lot of, even with priors, that there's still a lot of 0 sentences being withdrawn from some facilities?
Yes.
It's blank. They're changing it in Nashville.
They
A lot of those. What they're doing is, and it's not their policy right now, so I don't know why they are, but if it's a AOW and a PGA and a knife, then they're charging the AOW, let's say 24. And then when you go to the screen, has anybody gone to the screen, it says LPP and it's blank?
Yes.
Yep.
I was,
The D board's taking the time, and when it gets to Nashville, they're changing it.
so what does that mean? If it's blank,
I thought it was dismissed.
I thought it meant that was still.
Yeah.
Is that even like?
Think it's pending, think it's dismissed?
No,
Well,
that's what they're doing.
sometimes-
I asked about that. I said, I'm getting these and they're doing this policy midstream and it's confusing to me how it's not.
So if it's blank, that means the
They've
national.
overruled it.
Right, they've overruled it. They
Why
have.
don't they go back in?
I literally put
Not,
no
not
They have to go.
always. Not
That probably
always.
came in so much gone.
Yeah, not always. That's.
Not always. There are some,
Not always.
if it's no LPP screen, then they just didn't take time. But you don't see a lot of those
But
anymore.
sometimes it says LPP, but there's nothing, it doesn't say how much.
There-
I send those to Stall and say, can you check with T?
That is what's
But
happening.
that
And I don't
blank LPP doesn't mean 0 was taken, or does it?
From the D board, but when it gets to the commissioners designees, they go, well, that's not our new policy.
And so that blank will turn into whatever the designee decided.
Well, it just goes blank. It used to have a number because the D board put a number.
Mhm.
And when the designee looks at it, they blank out the number.
Why don't they put in their new number?
Yeah, I wanted to put it in.
Well, because
Zero.
they're not assigning any sentence credit withdrawal to that. Because as you say, there may be multiples and they're
So they
looking
just took
at
it on
it
the
as a
other
cluster.
charge.
Right. But that's not helpful to us.
No,
as
it's
a
not.
board.
At all.
And I don't know what we do with that. Because
Dennis, go
I
ahead.
talked to Mike and he said, and I'm like, you know how this is hard on us? He said, I'm telling my D boards, I've told them that it's 3 separate incidents. Let's say if it's AOW and then it's a knife or PGA, guys got 2 priors. So they take 24 on the knife, on the AOW, they take 8 on the PGA and 8 on the knife, because that's in the, the 2 matrix. And then it gets to Nashville and they're blanking them out, except for the main case.
So why is headquarters not following the matrix when the prison?
And I
is?
asked Mike that, I was like, so you're telling them to just do it like you told them, but sentence management's dealing with it. I said, but we're in this gap and we see blanks. What are we to do?
Well, what was his reason for taking away the 8?
Because that's a policy that's not,
Unofficial policy.
it's an
Right.
unofficial
We'll
policy.
change the policy. Very
But I said,
inconsistent.
he said, I tell him we'll just deal with it. You do like you're supposed to, we'll deal with it in Nashville. And I'm like, well, we're part of this as well. So we're gonna see blanks and go, well, you have to take it.
Sounds like more work for Stoll, because I'm gonna script a Stoll.
No, I mean, and I don't mind it. I don't mind it, but it's good that we understand what it means consistently as opposed to.
Maybe not always, but
guessing.
that's, if you ever see like it's
I see
usually a
that.
PGA or a knife or it's where it's a triple play or a double and that's what's happening.
So as a board, when you see that, you thinking they gave them 0 and you're giving them additional time, are you waiting? Because they could take 24, then someone else could take 12. The inmate is getting hit in multiple ways. So how do we, that's
Well,
it's hard
when
for us
they
as a
have-
board.
It's like 2 or 3 separate.
Yeah.
You had a cell phone, you had drugs, and you had this, and so each of those are being assigned.
And what,
When
But
it's overruled at headquarters, sentence management won't take anything because that screen says nothing.
okay,
Well,
so,
to answer your question, for right now, continue to do it how you're doing it. Bring it to us and we'll change it. But the process that Lewis was talking about was they're developing, it's kind of like SharePoint. Does everybody know how SharePoint is? Like you log in using your state ID, and if live changes are made, you see those changes. They're developing an Adobe system similar to SharePoint, where once it's gone through the entirety of the TDO process, once it's been through Ben and Tommy, once it's been through the wardens, the appeals done, there'll be that login that we'll be able to log into will say completed. And then we'll be able to see that this has been totally done and here's everything that's been done on it. And that way, at that point, once that system is up and running and we have access to it, there won't be that confusion and you won't feel like you have to change things. But right now, because that system isn't active, just continue to do what you're doing, where if you recognize that something wasn't done on an incident and it needs to be done, just bring it and we'll send in the action.
good deal.
Yeah, to me, it's confusing and I know it's not, well, it's like that.
Now, which
But-
step
but
do
like
we
a-
get inserted in? Do we get inserted right after the D board? Or do we get inserted after the designee?
That's what we're trying to solve, and that's what they recognize as an issue, and that's what they're hoping to solve with that new system. So they're in the process of developing and encoding it. We saw it. We sort of saw a portion of it, but it's not accessible for all of it yet because some of the facilities don't have the digital access. So, but to Mike Ward's point, they are moving forward on a lot of this, and the timeline has been pushed forward according to them. So we're hopeful that sometime in the next, hopefully by the end of this year, a lot of the new matrix will be available to us. This system will be available to us. And at that point, we'll see that we're being inserted at the end of it so that, because the other thing that we're seeing is decisions are made and then it's still going through TDOC's process. And then the appeals subcommittee will get something from an inmate that says, hey, the warden actually changed this. And then we have to do 2 action forms and all that. So right now we are sort of in the middle of their processes. We're trying to get to the back end, but until we can see the back end, we're just going to continue to do things how we're doing them.
On the one last note on the triple play,
Yeah.
on fight and a PGA, they felt the PGA was they just throw that in there because anyway, I can almost understand that. But if you find a knife, and you've brought this point up, Mary, and I agree with you on this, a knife, a cell phone, and drugs. You bought those drugs here, you bought the cell phone here. These are 3 separate incidents. And I was like, well, if he's a drug lord, then the phone is probably the most serious. But if he's a knifer, then I said, which one are you picking? And drugs are serious. If you got a lot of drugs, do you drop the knife and the cell phone? And I said, how are you making these decisions? Who's AOW is the top dog, but when you have those other ones, you see what I'm saying? It's like, and I don't know how they're doing that. So I'm gonna just keep doing that. There are 3 separate incidents for now. I think that's what we should do, y'all, until we get
What the
something.
policy says.
That's what the policy is, yeah.
Okay, Ms. Sharon, and anything else to add?
Yeah, just quickly, like I've said a couple of months now, and I think Dale said it earlier and some others, seen a lot more designated as Bs, which is troubling. I have 43 total pending incidents, some going back 10 months. Like I mentioned earlier, one's a drug possession from December. I just can't wrap my head around why they haven't fixed that. And we've sent it to Linda a couple of times. And I appreciate you, Mike. I'm going to keep sending you my pendings, and I know you're sending those to them. So thank you for that. But the inconsistent application, I've said it 100 times, so has everyone. You all have said that. The inconsistent application of their matrix is just very troubling to me. I see a lot of cases when they respond to my questions, they'll say that this was deleted or dismissed, but it's subject to reissue. Very, very rarely have I seen where they're actually reissuing disciplinaries when they say they're subject to be reissued. I'm sure y'all are too. The other thing is back in September on the 17th, when we met with them for their training, they talked to us about the 15 slide decks they have that they use for their D-board training. I don't think we've seen those yet. I'd love to see those the next time you're talking to folks over there, Mike Stahl. And that's all I have. Thanks.
All right. Good. Appreciate all that. We'll entertain a motion to approve the docket. Seconded. Any discussion about any particular incidents or anything Ms. Sharon had to say? Hearing none, move to a vote. All in favor, please say aye.
Aye.
All opposed? Okay, motion passes. Thank you, Ms. Sharon. And we have Ms. Wiseman next.
Okay, I will be very brief because don't look at my numbers as Jerry called it. Thank you, Mr. Bassbinder, Chairman. I transposed my columns like halfway through and I didn't catch that. So my numbers are wrong, but I also want to delete from my proposed docket 4 cases. If you go down to the second Northwest case, so it's 2nd, 3rd, 4th, and 5th, under that, where it says death, these guys beat a 4 inmate to death. I have the PDW, which I was thinking I could go up to 24, but I can't under the matrix. So they took 12 and I want to take 12. So can we just delete those 4 from my docket?
And keep that first one.
Well, no, keep the last one because on the last, so it would be like, it's Thomas 326095. That's the one you're keeping? No, this is
that's
the one
what
I'm
we're
gonna
getting rid of.
delete.
You're keeping that last one, 672134.
Yes.
Okay.
Because they took 3 and I want to take 12. If that makes sense.
Yeah, they took.
But they have all been, or
Okay.
several of them have been referred for prosecution.
Okay.
So I know that's confusing. My whole docket's messed up this month, y'all. I'm sorry. I don't
No,
know.
no, that's.
So I want to take those out and then not propose those changes, or I'm not changing anything now. And then, but keep that last one on that same incident number.
Okay.
And then ignore my numbers.
Where did
But
the
yeah.
transposition start?
I don't know. I know. I'm gonna have to go back through my whole thing and figure it out. I don't know. Jerry may be able to tell you. I knew my numbers. Remember when I emailed you this, I was like, something is wrong here, but I can't figure out what.
I know, I just looked at the format though. I didn't look at the numbers.
It's the 4. Read the rest down, it was transposed.
So right here, starting here.
Yes, sir.
Okay.
What would I do without Jerry? Thank you. But the intention is still valid. Like the cases I want to change are right. It's just if you look at the columns, some of them are backwards. Like, and by columns, I mean like how many priors versus how many months that were taken.
Okay.
So my proposed matrix column is still right. And, the only other one I wanted to like notate was the first Riverbend one. They took 10 months, but I just increased it to 12, which I know is not that much, but, because this guy was and he has 11 priors. He like reached through the pie flap and was like grabbing the correctional officer while, I can't remember, he or she was trying to like do whatever, serve meals or whatever. And, I just thought that was just so offensive, and he has 11 priors. And then, a couple of these I just increased because they have so many, and they'll give them the minimum. Like the last Riverbend one, he's 29 prior A's. Or a couple more down, he had 22. So I just think at some point you gotta max these guys out, and they don't. And I don't know if everyone agrees with me, but that's my logic. But I'm still staying within the matrix. And other than that, I didn't give any credits back this month, and I agree with Quantel and Lee. Like, for the most part, I mean, most of them they're doing the right thing on everyone, and like, it's just every once in a while there'll be a glitch. Like it's so different from how it was 6 months ago. In my opinion.
Great. Motion to accept.
Second.
Any discussion on any of those? All in favor? All opposed? Okay, motion passes. Thank you, Ms. Wiseman. Any other trends, any notes for the month?
I do see a lot of dismissals, and I do see a lot of change to be for no reason, like for no apparent reason, but
Okay, well, that's good to know. All right,
piggybacking what other people have said.
excellent. Thank you, ma'am. Okay, moving on. Mr. Dunn.
Thank you all. In the interest of time, real quick, the first incident under Morgan County, 1680077, I'd like to strike that from the page because that's been determined to be a B. And the incident for Trousdale.
Wait, I'm sorry, the second one from Morgan?
No, sir, top one, 1680077.
Okay, sorry, thanks.
It's all right. Strike that one from the sheet. And then the incident at Trousdale was 1682931. 1682931, we'll strike that one as well. Came up as a B. I saw a large trend in this docket of a bunch of unfinished matters, a bunch of dismissed, a bunch of cases changed to Bs. And just a couple incidents to highlight. Was an assault on assault on the staff with a weapon at Morgan County. The second one listed officer was transported with pretty decent facial injuries because during the fight, the offender took his radio from him and fumbled his face with the radio. And then further down the sheet at Whiteville, it's another incident like Betsy just mentioned. There's too many priors, and they're giving them the basic sanction instead of increasing to a higher up sanction. And right underneath that, the indecent also at Whiteville. They had one prior, and that prior was this incident of this charge was the second incident in 4 days of being indecent. So I'm not going to be lenient on that, and it's within the sanction. Reasonable sanction.
Yeah, Mike, how many days do you want to take? You've got on the matrix 3 to 4. What did you want to take?
That's what's allowed according to their sanction, but I'm suggesting removing 3 additional months. My suggestion over there to the right. That's my suggestion column. So, my apologies for my totals. They didn't make the sheet that I sent in. I apologize. I thought I sent in the sheet, the totals at the bottom, but I would have had to withdraw the 2 cases anyway. So it's 54 months being withdrawn for this docket. And I thought I'll have several pending out of this block that'll be addressed in the future.
No restoration.
No, sir, not this block.
You're a guy that keeps doing the indecent exposure. Who's been referred on both of them.
Good. Good deal. Yes, it's good to hear that, especially that facility. That's good. But I have seen a trend of the fact that they're doing what they should with our observation in play. So that's good. We're being effective. Back up what everybody said.
Great. Okay, well, if there are no questions about particular instance, I'll entertain a motion.
Motion on consent.
Seconded. All in favor, please say aye.
Aye.
All opposed? Motion passes. Thank you, sir. Any closing notes, anything else? Okay, great. Okay, and our last, presenter, Ms. Doyle.
You girl. Okay. Hopefully, Jerry looked at all of them after I did them, so, these are perfect. I hope. So I did, took 69 credits. I had 122 OKs. The matrix took 112. Well, the D-board took 43 and I took 69 more. And then, on my restorations, looking back, I took 14, I added 14. And that last one, that AOO, that number 168 should be 1684413.
4413. Okay, thank you. Great. And then at the bottom, we've got the Bs that should be As.
Well, Lee told me the one was just the A or B,
Yeah,
Which one?
the TS,
the PDR.
I have a PDR and I have a TSD.
So the PDR can be an A or a B.
Okay.
Yes.
Okay. And the TSD can be an A or
Or
a B.
B,
No.
okay.
No.
PSD's only a.
So the TSD is an A. What about the RA?
RA's only a.
Only an A.
So I
Okay.
have two that need to,
Okay. Do we have, if we change them, what are the recommendations you'd like to impose?
I didn't do that part because I didn't know I was supposed to. Sorry.
Okay, that's okay. Why don't you take these back and then you can look at them again? And what we'll do is we'll do an action form and you tell me that we want to recode them as As and this is the appropriate punishment
So the
based on the
TSD
number of priors and all that.
Okay.
Okay.
So I had, that was my totals, and then I have 4 pending, 54 dismissed, and I had 14 that were changed to these.
Okay, great.
That were supposed to be, that are okay. So that would, should be 15.
Okay, great. Any questions? from
I was just gonna make one quick comment on the dismissals. And Mike Ward was really specific. And I think when we get this new sheet, we'll be able to see why they dismiss, because sometimes they go away before you can see exactly why, and it's just gone. But he said and there's a cultural change here. We don't want dismissals they said the most irritating thing they see is, and I'm sure everybody's seen it, Sally took the charge. He said, we don't want to see that. He said that if we don't know, you're both in that cell, and if there's a cell phone, you're probably both in. And so basically they're wanting to, and I guess it's just taking some, pushing, some polling, and the dismissals, he said, we just hammer that home every day. I want to know why it's dismissed. Sally took the charge is not enough. I want you to show your work and this, that, and the other. So anyway, they're aware of the dismissals, and he said, we talk about it all the time. So
Okay.
we're hoping that gets better, or at least we know why they dismissed.
If Mr. Hall would like to go ahead and do, the PSD and the RAA, PSD had 1 prior round and the RAA had 3 prior rounds. You know, figure it out.
It's up to her. I mean, if she wants to make that decision now, or if she wants some time to look at it.
Hold on,
What would you
prefer,
prefer, Ms. Doyle?
let me get my matrix out. I'm sorry, I'm still muted. But I haven't-
No, you're fine. You're fine. If you don't want to do it now, you don't have to.
No, if it'd be easier, I don't mind doing that. Okay, So I'm asking a question.
Well, actually, all right, so if we're gonna have a discussion about it,
Yeah.
let's approve the docket except for the two we're gonna discuss. So,
Motion to approve.
any discussion on those incidents, those cases above the reclass incidents? All in favor?
Aye.
All opposed?
Aye.
Okay, so that passes. So now we're talking about the last two Class Bs that should be As. And, Ms. Doyle, you have a question about how you want to, sanction.
Let's just scroll them over so that I can look at them.
Okay,
That I can look at them.
okay,
Yeah.
not a
Don't
problem,
mind.
not a problem. Okay, we will notate those, for next month as well. But in the meantime, feel free to relook at those and then just add them to your doc.
Is that back to myself?
Yeah, that's right. Okay, great. Oh, I'm sorry. Any trends, any issues, anything
I don't
you're
have
seeing? Okay,
I mean, just the dismissals, but
sure.
they're one reason.
Okay, a couple more things before we pack up and go. We do have to offer a public comment period. I'm not seeing anyone online. There's no one left in the room, so we'll move past that. A couple of closing notes. November's meeting. November's meeting is set for right now our normal meeting date, which is the third Wednesday of the month. So that would be the 19th. Do we want to keep the 19th? Is that okay with everybody?
Did we not move to,
Sure.
did we move to second? Are we third? No?
We moved to the
I
third.
think so.
Oh, okay, yeah, that's good for me.
Okay,
For
so,
me, I mean, I'm not speaking for everybody else.
so our next public meeting will be November 19th, which puts our agenda setting meeting on the 12th. So keep those dates open, please. Also, when I distributed the cases for next month, they're in that new format. It helps Tammy out a lot if you can put your dockets in that format so she can take that information, put it in Excel. It automatically transposes onto the Word documents. It's just much easier for her. So if you got any questions about that, please reach out. If there's any issues, something doesn't look right, you're not really getting it or you don't like it, we can work around it. It's not a mandatory thing, but it would help her out immensely.
Do we have a time for the agenda set meeting yet?
Different. Yeah, Senator. The only other thing I'll mention is we do have a meeting set up for this coming Friday where we were going to continue our matrix discussion, but we did hear from Mr. Frank that Mr. Ward expects to get us a revised matrix pretty soon. I think we weren't expecting something till several months into the new year, but it looks like that may not happen. It may be much sooner than that. Do we want to cancel that meeting and wait for them to present us with their new proposal and then do our review off of the new proposal?
Motion to council. Cancel.
Okay, does that work for everybody?
Cancel.
Okay, that makes sense to me. So we will do that. I will cancel that meeting, so you'll see that update come through. And then we can just continue our discussion on some other things. We did talk maybe about doing an executive session and kind of talking about some things with our council. Do we want to set that up? Or do we want to leave that open?
Maybe see what the new matrix was.
Yeah,
Okay,
leave it open, the new
Okay.
matrix.
take it.
They solve some of our questions.
Okay, great.
Are we getting a matrix like that soon, like in the next few weeks?
The response was, I mean, what was the
What
direct
he told
response?
me, I said, because I was figuring February, March, April. He said, no. He said, I'm almost done. And I thought it had to go through this. I think they'd already kind of pre-done stuff, so.
And that's the thing, it won't be necessarily approved, but he'll get us what they're working on. He said he'll give us an advanced copy of what he's proposing to their leadership. And that's why I think it'll be much faster than that.
Maybe. I mean, I took it that, because I kind of went that way. It seemed like he was like, this'll be it.
Yeah, it should be. It should be. I'm just saying it won't be implemented by the end of this year, but, because they're going to marry it with some coding changes as well. So they're going to recode some of the A's and B's to make it clearer for people. Like right now, we're seeing some B's, could be an A or a B, but there's not a whole lot of instruction to DHOs about how they should be evaluating an incident to determine whether they're going to classify it as an A or B. They're going through all those codings and they're going to increase the description of if you have something that can be an A or a B, this is what you're looking for in order to determine that it's an A, or this is what you look for in order to determine that it's B. So they're doing all of that at the same time that they're redoing the matrix. So Mike Ward, from what I understand, can get us an advanced copy of the matrix, but we may not see everything implemented until early next year because they want to do all of those changes at once.
But we
So
will have a chance to say, well, could you tweak this?
that's the expectation. That's the expectation, yes. So if we want to put off some of these discussions until after that, we'll have more information at our disposal. Okay, great. Well, that is all I have for the meeting. I will pass it over to our chairman for adjournment or further discussion.
Is there any further discussion? Do we have a motion for adjournment?
Motion.
Second.
Motion in a second. All in favor, say aye.
Aye.
Hi,
Okay.
thank you, guys. See y'all later.
Okay, thank you. All right, we are off the record.
Bye, Sharon.
Hi, Reed.
I mean, how are you?
You want this really.
See.